It is 4 p.m. We're bringing developing news.
And the stories behind the headlines. This is Storycon. I'm Regina Lay.
I'm Ed Lingao. The stories we have today. Lawyer Levi Baligod and 18 of his clients claiming to be soldiers were at the Ombudsman today. They want the office to investigate alleged payoffs to politicians that include President Bongbong Marcos. The former soldiers claim to be bagmen for disgraced former Congressman Zaldico and are looking to present affidavits on supposed cash deliveries to government officials. Baligod reiterates that there is no high-ranking personality behind this revelation.
Meantime, attorney Levi Baligod admits an error in including ML Representative Laila De Lima as one of the recipients of suitcases of cash. In an interview with True FM's Ted Filon at DJ Chacha, Baligod said it may have been an oversight on his part. He added that De Lima was only listed because she attended meetings related to the International Criminal Court. Still, Baligod insists that the former senator and now congresswoman did receive a paper bag that could have contained between 5 to 10 million pesos. De Lima has since called the allegation quote-unquote preposterous.
Totoo po yun na 2025 lang siya, no? Pero ang binabanggit kasi nila noon ay nakakasama siya sa mga meeting pagpatungkol sa ICC, no? Kaya nilagay ko na lamang siya sa mga miyembro ng Congress. Pwede pong error 'yon, no, on my part. Pero I want to make it clear at this point na it could be an oversight for me na nasama siya doon sa listahan ng mga Congress members that created the impression na nabigyan din siya ng mali-maleta.
Palace Press Officer Claire Caso once again rejects the claims of Baligod and the former soldiers. She questions the motives of the accusers and singled out the involvement of former Congressman Mike Defensor. Defensor earlier claimed that a second batch of ex-soldiers is preparing to testify on the alleged multi-billion peso bribery of sitting officials under Marcos. She also alluded to a figure linked to the administration of former President and now Pampanga Congressman Gloria Macapagal Arroyo.
Mike Defensor, the known Wonder Boy. Marami sa kanyang talumpati ang naghihikayat sa ating mga kababayan na tanggalin sa pwesto ang ating Pangulo. Alam na natin ang motibo. Mike Defensor again, Ador Mawanay 2.0. Kilala ang salitang mawanay dahil sa pamimilit di umano sa kanya na gumawa ng peking salaysay. Meron tayong impormasyon na isang tao sa administrasyon dati ni GMA na isang operator na ang trabaho lamang ay to muddle the issues. Pag ang taong ito ay kasama sa isang issue, something is fishy.
The ICC Prosecutor's Office says its activities are funded through the court's budget. That statement comes after the 18 individuals claimed that former lawmakers funded ICC investigators. In a statement, the ICC office confirmed that all costs, including missions and investigations, were covered by the court's budget and were strictly managed. The office stresses that its funding is independent, transparent, and subject to established oversight mechanisms. Meantime, National Security Advisor Eduardo Año rejected claims that he received a paper bag containing money from individuals linked to fugitive Zaldico. Año added that his legal team will pursue an investigation to determine if the claims are part of a broader attempt to destabilize government.
And here are the other stories we're watching this Thursday, February 26. The National Unity Party, in a statement, says that it has not seen any new and material evidence in the impeachment complaints against VP Sara Duterte. The party says it will likely not support the measure or the impeachment complaint unless compelling new proof emerges. The NUP stresses that impeachment is for accountability and not politics and urges Congress to focus on more urgent national issues.
Senator J.V. Ejercito says the Senate Ethics Panel will hold an executive session on March 4 to start vetting complaints. He added that due to committee room unavailability, Senate President Tito Soto authorized the use of his conference room at 10 a.m. to expedite the meeting. That's in regard to the complaint against Senator Bato de la Rosa, which is among those that will be vetted that day. The lawmaker has been absent from Senate session since reports emerged that the ICC may have already issued an arrest warrant against him.
And joining us today from the Philippine Star, we have Editor-in-Chief Ami Pamintuan. Hi, Ami.
Hi Ed, hi Reg, hi everybody.
Hello,
Happy
happy
Thursday.
Thursday. Isang araw na lang at
Happy Thursday,
weekend
isang araw na lang.
It's a brown day.
Yeah.
So, di ba ang saya, lumalapit na Lunes ulit? Bakit ba?
Ay, nako,
To each
Ed.
his own happiness.
To each their own, that's right. Paper, brown is the color of the day.
Parang
Yeah.
paper
Brown
bag.
din ang color ng paper bag na allegedly
Ay,
binigay sa
just a
mga-
quick note kasi may interview kanina si Ted Filon and DJ Chacha with Attorney Baligod where yun nga, he said that may have been an oversight on his part na nasama si Laila de Lima. Pero merong atras abante doon sa interview na medyo magulo. Kasi sabi niya, she may have been included in the list because she was included in the meetings with the ICC. So nabanggit na kasama siya sa mga meetings. Kaya nilagay ko siya sa members of Congress. So sabi niya, it could be an oversight on my part na nasama siya sa listahan, yung maleta listahan. And it gave the impression na nakatanggap siya ng maleta ng cash. Kasi nandun nga siya sa maleta listahan na nakalagay dun sa affidavit. However, later on in the interview, may nabanggit siya na she may have received a paper bag of 5 to 10 million, which appears to contradict
what he said earlier.
What he
But you're
said
right,
earlier.
towards the end of that interview, sabi nga niya that, no, she did, tumanggap siya. Tumanggap si De Lima
so
daw.
si DJ Chacha says, so
So-
ano ba talagang totoo? Tumanggap pa siya o hindi? Kasi kanina, sabi mo, hindi siya tumanggap ng maleta. Ngayon, sasabi kang paper bag na may 5 to 10 million. So tumanggap pa siya o hindi? Ang huling sabi ni Atty. Baligod, tumanggap siya.
Okay.
So it's a bit confusing kung ano yung talagang...
But, I mean, since these allegations, of course, there have been a string of vehement denials. Yung latest is yung, what I just read, which is National Security Advisor Eduardo Año vehemently denying that he also accepted money. And by the way, si Año, I mean, I know it's a different story, pero somehow still related. Remember that Año's name appeared in the ICC confirmation of charges hearing. Although wala siyang picture. Remember when they showed the slides of the 9 co-perpetrators?
Is that the Matrix?
I don't want to use the word matrix kasi it has a bad connotation. Pero on days 1 and I think there was day 1 or when they
1 or
flashed
2.
the slides of the co-perpetrators, if you zoom in, it does in
As
the
chief of
chart,
staff
it
ng
does show Año's name because he was at one point the LG secretary.
Oh, yeah, the LG secretary.
So, of course, he has direct oversight over NBI. So, but hindi naman siya na-name as co-perpetrator. I'm just saying, this is one of those guys that crossed over from the Duterte administration to the Marcos administration. And
Yeah, we've also been trying to get. We've been trying to get the other people who were named. Of course, perpetually in our list is Martin Romualdez. Never naman sumasagot,
You
pero
won't get it.
we're always trying to get Martin Romualdez to respond to this. Also, we're trying to get George Garcia, Comelec, kasi napangalanan siya doon sa affidavit. Tumanggap daw siya ng ilang maleta. I think mga 3 or 5 maletas daw ang natanggap niya.
maleta or paper bag?
Maleta. Oo.
Baka may separate list kasi, which
Actually,
we haven't seen.
Binanggit yung paper bags doon sa kung ano yung mga pinaglalagyan ng pera doon sa affidavit. Pero doon sa lista ng mga taong tumanggap ng pera, walang nakalagay na paper bags.
Bakit daw kasama yung COMELEC chief?
Hindi ko rin alam. Wala namang paliwanag.
Hindi naman eleksyon yan.
Walang paliwanag. Wala rin kasi petsa. Teka. Let me check kung may petsa. Pero I don't recall kung may petsa.
Anong year yun? I was gonna ask.
I don't recall kung may petsa eh. Medyo
magulo na
labo-labo
kasi
rin
yung...
konti eh.
Yun na nga eh. Medyo... the
Basta,
timeline is a little bit
pinangalanan siya
all over the place.
among other people.
And then yung timeline din with the Lima is also unclear because of course she only got out of jail late 2023 ba yun? Was it late 2023, Ami? And of course she didn't become
Yes.
congresswoman until 2025.
Last year. No, last year.
And of course during that time before she came back to power, before she became a congresswoman. I don't think. I mean, the insinuation there, I guess, is that she was in on this. Na malaki pa rin yung influence niya,
Inaano yata siya because siya yung nag-initiate niyang mga human rights cases against Duterte nung mayor.
Oo, matagal na yun.
The Double Death Squad. Inimbestigahan niya.
She was the human rights chief at that time. So kung may tatanong yung ICC, presumably, tatanungin siya.
So ito yung the people we've been trying to get in touch with for reactions kasi sila yung pinangalanan doon sa affidavit. Si Chis Escudero, dahil di umunay nakatanggap siya ng 4 na maleta. Si Erwin Tulfo, nakatanggap
baka hindi
ng...
related dyan sa... Hindi na yan related
Di
dyan
ko
sa...
alam, basta I'm just... ito yung naka-enumerate. Si Erwin Tulfo daw nakatanggap ng 6 na maleta. Si Loren daw nakatanggap ng 2 maleta. Si Bong Revilla, 2 maleta. Tito Soto, 5 maleta. At si Mark Villar, 7 maleta.
Kasi wala namang issue dyan sa mga yan. Mukhang impeachment na yan eh.
I don't know.
But
I will not presume to
Kasi remember, they are just security escorts. They're talking about deliveries of maleta.
I don't know, Ami,
Hindi mo nila alam kung para saan.
but parang some people are trying to connect the dots nga between these two cases and trying to paint a picture na may collusion in order to take down some political personalities. Pero
kasi wala namang anong connection yan sa ICC. Yung mga senador na yan.
Tapos...
Lalo na sila Mark Villar. Anong connection nila?
Tapos well, kasi it also depends on how you intend to look at the affidavit. Is it primarily because with the angle of the ICC or basically...
Baka hindi lang ICC it's
basically
just corruption.
admin versus the Duterte group.
It's just corruption.
Ito pa, 5 maleta raw pinadala sa bahay ni Bongbong Marcos sa Ilocos. It doesn't say in the affidavit kung saan sa Ilocos. Pero in the press conference, and I remember this then, sinabi ni Atty. Baligod sa Paway.
Kasi kung related dyan sa flood control, consistent dyan yan kay Orly Gutesa. Parang continuation yan ng testimony ni Orly Gutesa.
Tapos nandun daw sa bahay sa Ilocos at ang tumanggap ng maleta na 5 ay si Sandro Marcos daw. Tapos 2 maleta para kay Amina Pangandaman, 8 maleta para kay Gregorio Katapang, ang Bucor Chief. Or is it the other way around? Si Katapang nagdala ng 8 maleta.
Baka si Katapang kasi may kumakalat na tatanggalin daw siya. He had to deny that story today.
8 maleta. Malaki yun At 8 maleta galing kay... O 8 maleta para kay dating Secretary Bonoan.
Kaya nga, related na. Wala nang kinalaman yan sigurado sa ICC. Nagka-mix-mix na yung flood control dyan sa kayong ICC.
I don't know, Ami,
Medyo
pero...
magulo na yan.
Yun na nga, kanina pa namin, we've been trying to make some sense out of this. Hindi kasi... But the good news is, I guess, pumunta na sila sa Office of the Ombudsman. So remember at the interview yesterday with Attorney Baligod, we were asking where his evidence was. And today, we heard that they went to the Ombudsman already. So hopefully, malalaman na natin yung some of these details and evidence that they have on hand. Because otherwise, it's hard to also to keep reporting about this when it's primarily he said, she said. Diba? Wala tayong, we have nothing to go by other than what people say. And of course, Malacanang has vehemently denied this already. Si Yusek Claire Castro called it purely fabricated and a lousy script. In fact, she was asked about the involvement of former Congressman Mike Defensor, and she called him Ador Mawanay 2.0. Explain mo sa mga tao na hindi nakikita ng context na yun.
Ni Panfilo Lacson. Yan yung witness ni Panfilo Lacson na bumaliktad. Kaya si Ping Lacson, ingat na ingat sa mga witnesses and their statements. Naging ingat sa mga retraction na yan. Sabi niya, napaso na ako dyan dati. He presented Ador Mawanay as a star witness.
But let me also add in na rin, Ami, kasi kahapon ang haba ng diskusyon, and I'm not really certain why we had to have a long discussion about it over kung ano yung hindi daw niya sinabi doon sa press conference nung isang araw. If you recall, ang sabi ni Attorney Baligod, he never said that the dollars were turned over to Sani Trillanes for the ICC investigators. He said he never said that. That's not in the affidavit. I went through the press conference again.
Sinabi niya yun?
I went through the press conference again just to be sure that I heard it right. So he talked about the dalawang maleta, I think 56 million each, converted to $2 million. And he said in the press con, pinaghahandaan nila ang pagdating ng foreigners na kalaunan ni nakilala na ICC investigators. And mga 2 sentences later, at binigay kay Trillanes ang pondo para sa pag-asikaso sa mga ICC investigators na ito. At makikita nyo ang madalas sa pag-deliver nila ng maleta at minsan mga paper bags para sa mga nag-aalaga ng ICC investigators. So that's what I was trying to say yesterday, that is what he said.
Which he denied at first.
Pero nila, di ba? Yan yung narrative ng camp na pinondohan nga daw ng gobyerno yung pagpunta rito ng ICC. Unofficially, kahit na hindi tayo nagko-cooperate. Pero nag-issue ng statement ngayon ng ICC.
Oh, yeah.
Hindi daw sila kumukuha ng panggasto sa ibang tao.
I mean, we knew that about the ICC, that they act independently. And I said nga kahapon, it's always top secret, right? Even if we want to know details about it, hindi nila sinasabi. But in any case, ito yung response ng ICC. It's a long statement, but I'll read part of it. The Office of the Prosecutor of the ICC independently collects information relevant to its investigations, identifies the individuals from whom it collects witness statements, and assesses the credibility, reliability, and relevance of all sources of information that it requests and receives. I'll skip a paragraph and then go to the end. The second paragraph basically said that they, as a matter of policy, do not comment on operational matters with respect to the ongoing investigation. But Office of the Prosecutor activities are funded through the court's budget approved by the ICC Assembly of States Parties and subject to established oversight mechanisms. The costs related to OTP prosecutions and investigative activities, including mission expenses, are fully covered by this budget and managed strictly by the office in an independent and transparent manner and in accordance with ICC financial rules and regulations. So this is quite a serious response from the ICC. And as they said, they don't normally comment on operational matters. And in fact, remember, we also tried to get them on a lot of things to comment on the events leading up to the confirmation of charges hearing, but they declined us, saying, we do not comment on individual cases. But I guess yung noise around this has gotten to a point where they felt like, okay, we have to address this now. We have to respond. So, ang pinapoint out ko lang dito is how unusual it is for them to respond to something like this, to respond to an accusation. Kasi even before, nung hindi pa nagko-confirmation of charges hearing, they were already being accused of, no jurisdiction, being biased, and so on and so forth. And whenever we asked them to come and comment on that, they would turn us down. Kasi nga, it's their policy. But again, this is what it's gotten to, wherein they had to issue a statement.
But let's bring in our woman from The Hague. She's now with us, joining us live.
Woman sa Hague.
Oh.
Sa Hague.
Ay, nahawa na siya.
Nahawa na sa'yo.
Okay, si Angela Gonzalez Castro. Angela, kamusta ka dyan?
Hi, Ange.
Nakamute ka, nakamute.
Mute.
Sorry, may entry din ako.
Ano?
Go.
Anong entry mo?
Sa Hague ng Sahig ng magaling ang masipag. Tama ba yun?
Ha?
Gets mo ba?
Corny.
Daig.
Daig, sahig nga. Sahig.
Angela, I know
Or, hey girl.
I know the
Or, I'm
Netherlands is a
hey
place
girl.
of
The hey
very
girl.
lax rules with regard to certain chemicals, but
You know what it is? I think the cold has gotten to her, no, Ange?
Yes.
Masyadong malamig dyan.
It's in my brain already.
Oh.
But anyway, I'm here right now in front of the ICC, wherein people actually tapos na, no, people were lining up here a moment ago for of course, no, inside to watch the confirmation of charges of former President Rodrigo Duterte. This actually technically day 3 of the confirmation of charges. And today is the schedule of the defense, no, to submit the merits on their case. So kanina, we were able to see Kaufman going inside, but nag-decline na siya to give an interview. We saw a lot of people here from different from two sides of the coin, pro and anti. We're ready to get inside. Talagang aabangan na lang natin kung ano yung magiging laman ng depensa nito ni Attorney Nicholas Kaufman. And for sabi nga natin, for context, this is the first time that we're going to see Kaufman in action, no, officially, because lagi na natin siya nakikita nagpapa-interview lang, yung mga snippet, mga pocket interviews. And the first time that we saw him talk is during the opening statement. Pero ito talaga, titingnan natin kung gaano siya kagaling idepensa itong si Pangulong Rodrigo Duterte. Kasi sabi nga in this world, no, in his world, yung itong dati siyang former prosecutor, 'di ba? Before siya naging sa defense, and he was a rock star, sabi nga nila. So we will see kung paano niya gagawin itong kaso, no, itong mga ebidensya na to para to defend the former president. Of course, kanina napag-usapan niyo na nag-release na ang ICC, no, ng Office of the Prosecutor, ng kanilang pagde-deny nga nito mga allegations made back home in the Philippines.
Yeah. And you've been there a few days, and I know that you've done some interviews with both the lawyers of the victims, pati na yung lawyers of the Duterte family. Mas klaro na ba at this point what the 6 lawyers of the Duterte family are there for and how they're helping the case? But by that, I'm talking about yung grupo nila, Attorney
The Filipino
Salpanelo.
Legal Council. Yeah. Okay, so I was with them yesterday for quite some time, and then of course I asked them kung ano ba talaga yung role nila dito. Merely observing lang talaga sila. They had social with Kaufman the other night, and sabi nga nila hindi naman nila masyado pinag-usapan yung case kasi social nga daw, but they were able to talk about the health of former President Rodrigo Duterte, and they said they're very worried about him because according to Kaufman talagang kumbaga sa salitang Pilipino, Reg, Ma'am Ami at saka Bok, nag-uulyanin na. Ganon, Kasi pagka tinanong daw, sino tong kakakausap lang niya dun sa bumisita sa kanya, pag tinanong daw kung sino yung bumisita sa kanya, hindi na daw niya maalala. No? Pero, after the presentation, the first day of presentation ng prosecution, di ba, we were able to talk to Kaufman also. And he said, nag-update naman daw siya kay Pangulong Rodrigo Duterte. And tinanong namin kung anong comment ni Pangulong Duterte. Sabi naman daw happy siya. Kasi sabi naman ni Kaufman, hindi naman daw nag-monitor itong si Pangulong Rodrigo Duterte. As for the Filipino legal team, sabi nga ni Salpanelo, they're just observing. And sabi sa akin ni Attorney Salpanelo, off-air, nung nagkukwentuhan na kami, kasi sabi niya kailangan talaga merong Filipino lawyer sa team ni Pangulong Rodrigo Duterte. Sabi ko, paano yun? Hindi naman kayo po pwede na pumunta lang doon kasi kailangan may accreditation. He said, nag-apply daw siya ng accreditation ng ICC, etong si Attorney Salpanelo, through his son, Paulo Salpanelo. Titingnan na lang natin kung ma-accredit siya. So, as of now, nakapag-file na siya ng accreditation para makasama siya sa legal team, supposedly nito ni Pangulong Rodrigo Duterte. At tinanong ko rin sila, Secretary Medellera yesterday, kasi sino ba? 'Di ba? Sino ba yung nagsabi sa inyo na kayo yung Filipino legal team? Family daw, mostly si Hanilet Avancenia.
Pero kailan
Kasi
siya
dapat
nag-file?
daw talaga, Bok, ang plano nila is to go here lang in visit, hoping to get a glimpse of the former president during the confirmation of charges. Biglang nag-wave ng right to appear in front of the trial chamber. So sabi na sayang naman, pero yun na nga nung sinabing pupunta sila pala lahat diyan, di kayo na yung Filipino legal team na ni former president.
Pero kailan lang siya nag-apply to be accredited by the ICC?
Hindi niya na sa akin yung information, pero sabi niya nag-apply na yung anak ko para sa akin, sabi niya. So antayin na lang natin.
And why is it through his son? Bakit kailangan sa anak?
Oo nga sabi ko sa kanya kasi siya yung anak daw niya yung may alam doon.
Siguro
kailangan ng
online application. Hindi siya
So actually habang nag-uusap tayo ngayon, kararating lang kakapasok lang ni Bello, former Dole Secretary Bello, at saka ni Delgra, former LTFRB what's his name, Martin Delgra and Panelo. Okay, so so nandito na sila, pumasok na sila.
Approve na rin ng ICC yung request ni
Yes po.
President Duterte. He will also skip the hearing sa detention niya.
Well, that's kumbaga parang inaasahan na rin natin yun kasi according to Attorney Christina Conti, kung pinayagan nila na hindi mag-appear dito for the duration of confirmation of charges, what more pa dun sa 1 hour na detention review. So most probably approve nila yan. So yesterday at around 4 in the afternoon or 4:19 in the afternoon to be specific, Hague time, naglabas sila ng statement dun sa GC namin para nga maipalabas namin itong kanilang decision.
Marami yung pumapasok dyan sa likod mo, Ayun,
yes, Kasi magsisimula na siya in about 30 minutes ang confirmation of charges. So mamaya, after ko kayo kausapin, I'll go inside para makapakinig din ako. Kasi kami, di ba, advance kami ng 30 minutes para makakuha ko ng information.
I'm looking at the basic eligibility requirements to be included in the ICC registry of the list of counsel. The minimums are you have to be a lawyer, you have to be lawyer of good standing in a national bar, 2 years of relevant experience in criminal and international criminal law, and international humanitarian law, and in human rights law.
Pero kasi parang hindi ata ganun kung sa practice meron.
Hindi ko sinabi yun,
Pero sa human rights, we don't know that.
Hindi siya sa international law, hindi ba?
Oo.
I mean, hindi human rights siya.
Hindi rin
si
humanitarian law.
Attorney Harry Roque pa, di ba?
Pwede.
Yes.
Harry Roque pwede.
Pero kaso hindi siya po pwede dito.
And you should have no serious criminal or disciplinary record.
He doesn't have a criminal record.
I'm not implying anything. I'm just giving you the requirements.
Ange, I was curious about the crowds, both the supporters and both those who are protesting against the war on drugs, the rallies. Kamusta naman? It's day 3, day 4 now.
Day 4 now, pero day 3 technically sa confirmation.
Is it growing? Are the crowds growing, or is it the same number, or mas kumukonti na ngayon?
Ngayon walang protesters on the ground, Very clear ngayon ang paligid namin. Ang meron ngayon dito yung linya nga papasok ng yung public entrance para makapanood ng confirmation of charges. At basically, while we were talking to the people here, mix na siya ng pro and anti-Duterte na papasok inside. Kasi dito, pag public through public entrance ka papasok, first come, first serve basis. Kaya kanina maaga pa lang, may mga linya na hindi katulad namin na meron kaming ID. So anytime, we could go in and out. Sorry, isipon na ako.
Yung public, Angela, kailangan mag-apply pa online. Hindi ba nag-a-apply sila? Para lang hindi magkasabay-sabay ng pasok dyan.
Opo. Ganun po yun. Pero pa rin siya, first come, first serve basis.
Okay.
Ange, go ahead, Ami.
Hindi, tatanong ko lang kung ano yung capacity. Parang maliit yung chamber for an audience. For observers.
I'll let you know about it. Tatanungin ko muna. Pero kasi doon sa side namin, binilang ko, dun sa side namin, sa may media gallery, kasama namin kasi of course, yung Filipino Legal Council ni PRRD, tapos yung media, tapos yung ilang kaanak ng biktima, tsaka ilang mga human rights advocates, sila Attorney Christina Conti. Siguro more or less mga 50 yung side na yun. Mga ganon. Doon sa side namin na, oo, doon sa public entrance, hindi ko alam, hindi ko pa, I'll let you know, I'll get information regarding that and I'll get back to you.
And so coming back to the statement that the ICC released about how they fund their investigations and how, all of this is covered by strict ethics rules. We were saying earlier that yung ICC doesn't normally comment on operational matters, right?
Yes.
Did you get any backstory as to what got them to this point na feeling nila they have to issue a statement in regards to how they conduct investigations?
That's true, Reg, pero feeling ko kasi nabombard na sila ng media ng Pilipinas eh. Lahat kami nag-message kami kay Caroline, ang spokesperson ng ICC. Tapos even si Miss Paulina Masida ng Office of the Public Counsel for the victims, message na namin to get information So siguro kaya they needed to release statement. Yun ang nangyari.
And kasi these are very serious allegations being made by the Camp Baligo, the graft and corruption, and yesterday dumagdag ang bribery. And then they also released photographs of what appears to be, or at least from that perspective, mukhang itsura ng isa sa mga ICC investigators.
Exactly. So pero wala pa silang
ICC is also under fire from other countries and other quarters. For integrity issues, no? Simula dun sa kanilang chief prosecutor hanggang mga yung ibang member.
Actually,
I was answer that question.
That's true, kasi nga talagang the whole world is watching ICC in this procedure. Pero kahapon nung kausap ko si Attorney Salpanelo, natanong ko siya regarding this sabi niya he strongly believes itong mga allegations, itong mga accusations na sinasabi nila Attorney Baligod pero tinanong namin siya, pero paano yun kasi isa sa mga sinabi nilang nakakuha ng pera si Congresswoman na Laila de Lima. At that time yata nung sinasabi nila na may bayaran, nakakulong pa siya noon. Sabi ni Attorney Salpanelo, yan ang hindi ko pa nakikita. Pero sabi niya, overall, he strongly believes yung mga allegations. When I asked naman Attorney Gilbert Andres ng Common Legal Representatives for the Victims, sabi niya, fake news yan and I believe na independent ang ICC at hindi sila ganun. Yun ang sabi niya.
Fair enough. Okay, thank you so much. That was a great report. Angela Lagunzad Castro reporting to us live from The Hague. Pasok ka na, Angela. I know it's starting soon.
Thank you.
Thank you, Angela. Okay, you're watching Storycon on One News. We just need to take a very quick break. Please stay with us. We'll be right back.
This is the Story Conference Group, or the Storycon Group.
We've got developing news in the stories behind the headlines. Welcome back to Storycon, the Story Conference. I'm Ed Lingao.
And I'm Regina Lay, still with us, Ami Pamintuan of the Philippine Star.
Bok, I'm just going to the comments of remember kahapon kasi may storying lumabas sa One News sa TV5 tsaka sa Philippine Star.
Yung edited photo.
Oh, yung litrato ng tatlong I think mothers sa mga alleged victims ng EJK.
Well, family members of the victims.
Oo. Kasi lumabas doon sa page ni Cathy Binag na may dala sila mga bag na mukhang mamahalin. Ang sabi ni Angela, our reporter from The Hague, si Angela ang kumuha ng picture. So wala talaga silang dalang bag. So mukhang in-AI. Now, you have a lot of back and forth ngayon sa comment section of people claiming na hindi AI yan kasi
inedit lang.
Nag-iba daw yung picture ng konti yan. May pagbabago daw dun sa background, dun sa position ng mga kamay and all that. They tend to forget na when you AI a photo, an original photo, and ask AI to add something to it, nagbabago talaga yung ibang elements at kumikinis yung mga ano.
I mean, I think the point is manipulated talaga yung photo.
Yeah, but
and some,
people are a lot of people are saying na hindi pareho yung totoo.
No.
Hawak lang yan ng mainstream media. So pati tayo dinamay.
That's not new that we always get accused of being biased, but
The sensationalized, biased media.
na bayaran daw, which we are not, but
So for
people
those of you-
people believe what they want to believe.
For those of you familiar with AI, if you ask AI to tinker with an original photo, it will add the elements that you want to add to it, but it will also tinker a bit with some parts of the image. Also, AI does a lot of enhancing.
But yun nga,
Kasi yun yung normally gusto ng mga tao.
Pampaganda ng mga selfie.
but some of the photo experts early on already said mukhang manipulated because the arm positions were different. If you zoom in and you look at it carefully, makita mo yung parang hindi ganun ka linis yung pagkakaayos. It's not that smooth. And remember the small scandal with Catherine, Princess of Wales, wherein she posted a photo of her family after she went quiet for a while. And then
Yung hand niya, wrong position.
Exactly. So a lot of photo experts, criticize it, saying this looks manipulated. It looks like it was already edited somehow. And then the British Palace was forced to admit na, okay, yes, she edited that photo. It's the same thing with this one. Before pa na disprove that this was a manipulated photo, a lot of people on my feed I saw were already saying na they touched that photo already. They edited that photo because if you look at, there are some elements of photography that you can use to compare something that's real with something that's been touched.
Tsaka sa huli po, yung reporter na kumuha ng picture na yan, siya na nga nagsabi siya yung kumuha. Yung reporter ko sa natin kanina, siya na po nagsabing siya yung kumuha ng picture na yan. Pagpipilitan pa ninyo.
Walang bag.
Pagpipilitan pa ninyo na hindi, nag-post sila ng walang bag, tapos nag-post sila ng may bag. Yung mga ganun sa komento, parang, ha? Oh well, anyway. It'll never end.
No, it will never end because people will believe what they want to believe, right? Polarized talaga. Of course, people,
Yeah, but it's no excuse.
It's no excuse,
People
of course,
believe
to be sharing fake news like this and to, inflame.
To stand your ground because you want to believe what you want to believe. Okay, there you go.
Yan yung mga AI, yan yung iniimbestigahan ng susunod na guest natin.
Ay, wala pa yan. Yan naman?
AI altered information, misinformation, disinformation, nandiyan na siya.
Oh, he's here na.
But that's difficult to try to get ahead of the AI manipulation. It's just like
Although,
at the
yung photo, matagal na yan ginagawa sa mga ibang Photoshop.
it's just like the
Panahon natin Photoshop eh.
Photoshop, pinatatanggal yung mga wrinkle.
panahon ko Canva na.
Ano?
Canva.
Ano yun? Ang alam namin,
Natatanggal yung mga
ang alam
wrinkles.
namin ni Ami na Canva, yung canvas.
Canvas, oo.
Alam ni Ami yung Canva. It's a
Ah.
very useful tool for making presentations,
Yeah, okay, I should learn
notes,
that. Okay.
ganon. Okay.
Okay, let's bring in our
All right,
next guest.
let's bring in our first guest today. We're talking to, newly minted National Bureau of Investigation, or NBI Director, Attorney Melvin Matibag. Welcome to Storycon, Attorney Matibag.
Hi,
Good
Atty.
afternoon. Salamat sa invitation nyo at sa inyo rin po mga televiewers. Good afternoon po.
Good afternoon, sir. Thank you for joining us. I know you're very busy, especially nakaupo lang ninyo at I'm sure you're catching up with a lot of things. Ano po?
Pero I guess we can start with what we were just discussing now, which is yung
AI.
fake news na photo na nag-viral. I wonder what you guys are planning to do about the proliferation of fake news, fake images like this, or doctored images like this.
Well, that's a very timely question kasi just this morning I had a meeting with the Executive Committee of CICC together with Secretary Henry Aguda of the ICT. And we are partnering with private entities for us to address that problem. Sabi nga, yung biro nga kanina sa ni Secretary Aguda, tulungan mo kami, marami tayo ipapakulong. So we will go after them. We will be using modern technologies also para mahabol namin yung mga tao na nag-proliferate niyan. And speaking of fake video and fake news, recently we just filed cases to those individuals na nagkalat ng fake na medical certificate of President Bongbong Marcos. So kinasuhan namin 3 individuals, and we will target everyone who will proliferate the fake news. Kailangan namin ma-address to.
Yung si Sir Jack, di ba? Yung si Jack Argota, Sir Jack Argota, parang ganun ang pangalan.
Jason Sa and Celis, Edwin Celis.
Anong charges, sir? Cyber libel?
Yeah, cyber libel and also violation of Republic Act 154 is yung use of fake na mga news and fake na articles. There's a provision in the code na revised penal code article 154 na pag nag-publish ka ng mga na news or anything na which will create trouble, pwede ka maging responsible under the law.
Attorney, marami ng ganyang case, no? At saka ang common na naririnig naming excuse, nung iba lang naman, hindi yung principal. Sabi nila, pinick up lang naman daw nila sa internet at nirepost lang nila. Kasi, syempre, pag nagre-repost, may mga nakukuhang mga, mga nagfa-follow sa kanila. Yun ang common excuse. Ano po yung masasabi niyo kapag gano'n ang excuse?
Well, the Supreme Court already gave a guidelines on social media postings. Ano po? Kung ni-repost lang na walang caption and all, medyo defensible. Pero kung ni-repost mo at naglagay ka ng caption pa na it already violates the cyber libel law. Ito naman po yung revised penal code na 154 na yan, meron po kang document na inilabas, ginamit mo, ikinalat mo publicly, na it will create chaos or reaction na mali po. So, meron pong batas, and because of this, we will also be coordinating with our legislative body na magkaroon pa po ng mga laws to address this.
May
Ano po kayo? Kasi yung iba talaga, innocent talaga yung pagre-repost nila eh. Halimbawa, may nakuha silang interesting, kinakalat nila, tapos hindi naman private kasi yung nila, nagiging public, yun ang magiging violation, Pero yun ang sinasabi nila, interesting lang yan, kaya nirepost ko, bahala na kung sino makakuha.
Mahirap po yung ganyan depensa because from the point of view of law, it will boil down to the intent. Bakit mo ipinost? Hindi mo ba? Bakit mo ipinost yan? Like, let's cite the case of Jason Sa. Bakit niya pinost? It appears from the caption that he wants to create political upheavals. Di po ba? So, ang lesson po dito is let's be responsible in using social media platform. And kung hindi po sigurado, huwag tayong mag-post. Huwag po tayong mag-caption ng mga sasabihin natin. Huwag tayong mag-comment. Because there is a law that will make you answerable po sa mga ganyan po pagkapangyayari.
You know, sir, there's another loophole here, which is I foresee that a lot of people will say in defense na Well, I'm just asking. I'll give you a very concrete, recent example. When Attorney Harry Roque posted that photo of President Marcos and insinuated that he had a colostomy bag, nakausap namin si Attorney Roque after that, and he said, hindi ko siya inakusa. I was asking. And it is a matter of national interest. So, if you add just one question mark at the end, apparently, that's a way out. What do you think?
Well, that will be his defense. But you have to go to the law for the court to determine what is your real intent. So series of events po yan, series of documents, pieces of evidence that will be collated. Tapos pag kinasuhan ka, then the court will be the one to process kung ano ba yung intent mo. Kung totoo ba yung sinasabi mo na question. Kasi by just putting a question mark, it doesn't mean that you're asking a question. Doon ko na nga po ibabalik na the court will look on the intent. Kami rin po, sa law enforcement, from the National Bureau of Investigation, we will look into the intent for us to determine if there is a probable cause for us to indict you in court.
Kasi sir, some people would use a question mark to avoid the appearance of imputing malice. On the other hand, the fact that you have reposted something and just include the question mark may already be malicious imputation. But how do you strike that balance? Yung kasi sa huli, di ba? Yung paano pagbabalanse na gusto ko talaga magtanong versus gusto kong magtanim ng malisyosong pananaw.
Saka down the road, sa ganyan mga problema, Director, makikita natin, someone might challenge it on the basis of freedom of expression.
May ganun pa.
Nakikita ko yan. Yung ganyang mga problema, it will be a constitutional issue.
Well, actually, no, because alam naman natin, there's really a freedom of expression. But corresponding for every rights mo, meron ka pong responsibility eh. Kaya nga po, the Supreme Court already laid down the rules kung paano yun sa posting. So if you feel, nakikita mo, it will violate that rules na sinabi ng Supreme Court, then malamang you're liable. Kaya nga po, ang pag-prosecute natin, it will start to investigation, then there is a determination of a prima facie or a probable cause for you to indict that individual for doing so, then it's the court who will determine if it's beyond reasonable doubt na you're guilty of cyber libel or any law na ikinaso po sa'yo.
Saka lalo na kung government official ang involved eh. Di ba mas malaki yung leeway doon ng mga tao, ordinary people, yung freedom of expression ng mga tao, hindi ba? If you are criticizing, kahit malicious yan eh. It's a public official eh.
Depende po yan. You will really, it goes down to that. Let's take for example, a person, alam naman niya, na ngayon pwedeng mag-fake ng mga video without you verify ipinost mo. Tapos sabihin mo, hindi, binigay lang sa akin to, freedom of expression, I want to inform the public. To be responsible enough before po i-post yan.
Sa tingin nyo, we need additional legislation kasi alam ko sa Singapore, meron silang law doon na kapag sinabi ng gobyerno, yung pinost nyo yan, hindi totoo, you better take it down.
It's called
At hindi mo tinake down, you are liable. Dahil talagang sinabi na ng authorities, fake yan eh, nagkakalat ka ng fake news. Pero tayo meron bang ganon?
Well, it's called the
or do you need additional legislation?
Well, that's the one that I'm saying earlier, that we will coordinate with our legislative body for us to come out with a better set of rules, probably based on what the Supreme Court have already been laid down in the case that they decided for.
Yung law na yun, sir, is called POFMA, Protection from Online Falsehoods and Manipulation Act. Again, coming back to yung question mark, there's another way that people reframe it, right? So, for example, in the example that we were just talking about, yung photo of the relatives of the victims of EJK na may hawak na mamahaling bag, in the blurb, in the caption, she wrote, if true. You know, again, may qualifier, if true. So, yeah, there you go. Hindi ko mabasa yung full caption. But again, you know, how are you guys planning to handle that?
Well, as a primary investigating body, we will go to the source po. Sino yung nag-post, mahanapin natin ano ba yung original na picture talaga, paano minanipulate. So wala pong pinag-iba yan sa mga deepfake na nilalabas na titingnan mo, nakala mo totoong-totoo, tapos gagawa ka pa ng parang event para sabihin mo, ito, ipapakita ko sa inyo na may ganitong ginawa tong individual na to. Only to find out, pag tinest ng forensics, ano pala, fake pala. Pero yung pagsabi mong if true, at yun naman pala, manipulated pala, yun ibig sabihin, you should be responsible enough na bago ka mag-post, na chinek mo talaga kung authentic or talagang may pinanggalingan yung iyong pinopost.
Mhm. Well, sir, you made reference earlier to, I think, Article 154 of the Revised Penal Code. That's the article on spreading false news that makes it punishable by law. I'm also wondering kasi it's a 1930 or 1950 law? 1932, di ba? Revised Penal
Time
Code.
to update it.
Long time ago.
I think 1930. It predates pa the
The Constitution.
It predates the Philippine Republic.
Sila pa po.
Pero sir, what I mean to ask is this kasi exactly how do we define fake news or false news na ginagamit dito eh? How do we define false news? Kasi there are also times when, well, like it or not, there are times when government lies. I hate to put it that way. But,
Or
di ba?
they push their agenda.
There are times
So
when...
nagsinungaling talaga eh. But this is a medical record.
Yes, sir. Yes, sir. That's fine. That's fine.
You know that there is an implication. There is an implication because kung sinasabi ni ma'am kanina na pwede kasi public official, you should also be sensitive enough. The public official may responsibility rin. That is yung health niya, binilabas mo, tapos peke pala.
Yes, sir.
Di sana pumunta ka muna sa St. Luke's, tinanong mo, ito talagang medical issue ninyo. Validated ba ito na ganito?
Yes, sir.
Pero alam naman po natin, and you go back to their old, yung mga old na postings nila, alam mo na there is a political undertone doon sa ginagawa po nila.
Yes, sir.
Siguro,
I know what
it
you mean.
will be differently if an ordinary individual na nagtanong, I came across with this medical certificate, is this authentic? Totoo ba to? May nangyari bang ganun? Hindi. Magkaiba eh. Magkaiba po. So sabi nga, we all go back to the intent. You go back to the intent nung pong naglabas po nung dokumento at nag-post po.
I'm not talking, sir, about the specific case dun sa
Medical
Harry Roque
certificate.
case about the supposed colostomy bag. I'm talking in general. How do you strike that balance between, kasi like I said nga, there really are times when we catch government officials not telling the truth, and that's part of our job. And sometimes government officials will also challenge us by saying na that's not true. I am innocent. Sometimes may ganung banggaan eh. So, pag umabot sa korte at ginamit yung 154, paano yung pagtitimbang nun?
Well, the court will look into the veracity of the document. So malalaman din po yun, di ba? Kasi it's easy to spot manufactured evidence eh. Makikita naman po natin yun eh. So, let's say, anong document? I am citing the example, ang pinakanadaanan natin, yung St. Luke's medical document nga. You can spot if it is fabricated or mali. Hindi po ba? So, you will be afforded, will be afforded sa court na ano. Ngayon, kung iba naman po yung nagsisinungaling talaga yung government official, because if it will be subjected to investigation and trial, makikita na po ron, nagsinungaling ka pala talaga eh. So, totoo naman pala yung sinabi. Pero at the end of the day, if we go to the libel law, whether it's wrong or right, totoo yung sinabi, if there's a malicious imputation
it's material.
of something, mananabit pa rin po eh. Hindi po ba?
Truth is not a defense in libel.
Yeah.
Are you...
Oh, it's the intent. Yun nga po yung sinasabi ko, you go to the intent.
Malis ang ano. Malis
Yun po
yung test sa libel.
Opo. Yung intent nga po, ma'am. Yung intent nung
Okay?
Isn't there a danger here, sir, as well, na you end up going only after the enemies of the current administration? Because you keep bringing up the case of yung fake medical report. That's just one case out of how many? Thousands, hundreds of thousands of online falsehoods, right? How are you going to prioritize here?
I'm citing that example because that's the one that's happening, but it doesn't mean that we're only going after them. Marami po kaming cases dito ng mga ordinary citizen. Every day, may mga nagpapile and we process it every day. It so happened that that's being publicized. That's why that is the one being cited as example.
Okay.
Attorney, pahabol ko lang. I know you've been asked about it. Sabi nila, you've long been identified with the Duterte administration. Nagulat sa mga tao.
I was going there.
Kung bakit kayo po kung kayo napulit para sa napili para sa NBI. Can you tell us about it? Paano po kayo na-recruit?
Well, unang-una po, meron na, may malis na kagad na ako yung Duterte.
Yan yung pagpasok niya.
Government service long time pa po. Since 2005, I've been serving the government. I served the government, the administration of GMA in the capacity of director in the LLDA, general manager of the Manila International Airport. Then at the time of Pinoy, I was consultant in several agencies. Tapos kay PRRT po, yun na nga, nag-transco ko and naging cabinet secretary. And I will be the one to mention na Secretary General ako ng PDP Laban. So politically connected to the Dutertes. And I think I'm the one who served them well. Kaya nagkaroon ng away yung action ng Coco Pimentel at ng Duterte. I was the lawyer for that and I'm speaking for them. Pero ang sa akin po rito, siguro, I better be judged on my track record rather than doon sa sino yung mga nakasama ko. Because if I will be judged sa mga nakasama ko, long line of list po yung mga nakasama ko eh. In fact, I have to say this. Noong 2016, hindi naman po ako nag-campaign kay Pangulong Duterte. I was campaigning for Mar Rojas at that time. So ang tinitingnan ko po dito kung sino yung tingin ko na makakatulong sa atin at makasama. Tayo po, public servant. When I was recruited to be part of the Marcos administration as the NBI director, ako po tingin ko, ang tiningnan naman doon is my track record. And besides, hindi po pwedeng sabihin ng mga tao na ako ay sumabilang ba ako. Dahil if you remember, in 2022, when the campaign period, PDP Laban is campaigning for the unity team.
Yes.
Bongbong Marcos and Sara Duterte, President and Vice President. Kami po yung nag-campaign. And I've been longing to serve the government from the time that the President Bongbong Marcos assumed office. In fact, I will not deny it. I applied for a position. It's only now that I've been recruited.
Sir,
okay.
to be very clear to all the people who are seeing the chatter online, you would not classify yourself as a Duterte ally. Is that correct?
I served the government during the administration of President Duterte. So at that time, if they will define it that I'm an ally, then that's their definition.
Yes.
But siguro, I'd rather be defined from what I did and what I'm doing and what will I do as the director of NBI.
Director, if I may ask, ano po yung in-applyan nyo ng 2022? You said you applied for a position?
I'd rather say not, pero marami po. And kasama po dito yung
Marami.
Lord. Opo.
So
okay.
did this appointment come as a surprise, sir?
Well, I will not say na surprise kasi mahabang process naman po yung pinagdaanan ko. I was so before I came into the position po.
Okay.
Okay.
We'll leave that there.
Okay.
Thank you so much for talking to us.
Ami, malicious ka.
Tinatanong ko yung tinatanong ng mga tao.
Pag-usapan natin, sir, yung involvement ng media here. But anyways, another day. Thank you so much for talking to us today. National Bureau of Investigation Director, Attorney Melvin Matibag.
And we're on until 5:30 p.m. Storycon will be right back after a quick break. Please stay tuned.
This is the Story Conference Group or the Storycon Group.
Welcome back. This is we're in the last stretch of the program. This is Storycon. I'm Regina Lay.
I'm Ed Lingao, and of course, with us, Sami Pamintuan of the Philippine Star, and also joining us this afternoon, former Congressman Mike Defensor. Congressman Mike, thank you for joining us. Welcome back to Storycon.
Yes, Ed, thank you so much for having me. And of course, Ma'am Ami, Regina, magandang hapon po sa inyo.
Good afternoon, sir.
Good afternoon, sir.
Congressman.
Sir, ang sinasabi ni Claire Castro, isa kayo dun sa mga nag-organize nung press conference ni Gutesa at bahagi
Hindi
kayo?
lang ikaw, hindi lang yon, but that your Adore Mawanay 2.0 and the so-called boy wonder. Clearly, she was not very flattering.
Yes, well, first of all, yung Adore Mawanay, it's a wrong spin. I'd like to address that to you, Sir Claire. Kung gusto lang i-spin yung story, I think that's a wrong spin because I was never involved in the Adore Mawanay issue. I think nami-mistake nila dun sa Udong Mahusay issue because there was an instance before in the past na yun nga, yung supposedly na kinidnap si Udong and yun na yung issue. So that's a different issue altogether. Walang involvement of witnesses in that particular case. Now, in the supposedly I was involved, siguro masasabi ko, hindi ako involved in a sense na I spoke to the soldiers. I know I was involved in the affidavit o yung kwento nila. No. But yes, I'm helping them out and I will continue to help them. And I believe in what they're saying because precisely, ito yung sinasabi ni Gutesa. So ako personally, nung narinig ko na lalabas itong mga sundalong to, nabanggit ko kay Attorney Levy that I will help out. And I will continue to help them because what they're saying is correct. Now, in particular, dapat ang tingnan nila is the real issue. Totoo ba itong mga delivery? Ang daming pictures, pati yung picture ni Gutesa nandyan.
Teka lang.
Delivery ng mga pera. So, ito yung mga dapat i-address nila.
Sir, before we get on to the deliveries, the implication there is that you're more than just helping out, that you're actually one of the ones behind this and organizing this. Is there any truth to that? And secondly, when you say helping out, ano po ibig sabihin nun? Do you mean you're funding it? Do you mean you're helping with logistics? Do you mean you're coordinating with the 18 gentlemen? What is it?
I will help out in whatever way I can because what they're saying is true. But that the government should address the issue, Bongbong Marcos should address the issue, the senators and the congressmen, ano yung perang dinideliver. Yung ICC should be addressed. Yung in-address ni Senator Trillanes that did not come from me but the soldier. So, kung ang tanong lang mastermind ako, hindi. Dahil wala naman akong alam sa kwento. Hindi ko alam yung mga delivery, hindi ko alam yung mga pictures. Pero kung tutulong ako sa kanila para ilabas ang katotohanan, I will continue to do that.
Ikaw ba ang former GMA cabinet official that Claire Castro was referring to? Do you think that was an operator and every time daw this person gets involved, something is fishy?
I don't know what you're saying. I think the issue should be addressed. Kung may hindi totoo sa sinabi ng Marines, edi sabihin na hindi totoo, may fishy. Then I will tell the Marines, ito yung issue dyan, ito yung problema. But as far as I'm concerned, I will continue to help them. And those who will come out in the future na magsasalita sa korupsyon sa bansa natin, I will continue to help them as much as I can.
Pero sir, may ilang naging problematic na instances. Like for example, this morning si Baligod, si Attorney Baligod, said the inclusion ni Laila de Lima dun sa maleta receiving case, maleta receiving accusation, may have been an oversight on his part. Actually, confusing pa nga pagkaka-interview sa kanya kanina kasi sabi niya, it's an oversight on his part, sinabi lang si De Lima dahil nakikipag-meeting siya sa ICC. Pero sa huli, inulit naman ni Baligod na tumanggap si De Lima daw, hindi ng maleta, pero ng paper bag.
Although yesterday sa atin, sinabi niya na maleta.
Oo, so which
parang
one
nag-iiba
talaga?
Hindi naman may iba po yun, Mamami, Regina, kasi, Ed, dahil nasa affidavit na pinirmahan na yun sa notaryado. Kung magkamali man ng paliwanag.
Sir. Hindi po siya, it wasn't signed and it wasn't notarized. We asked
No. There's already a signed affidavit.
Was that yesterday?
Sabi ni Baligod. Can I just finish the story?
Sinabit siyang ombudsman.
Can I just, so si Attorney Baligod, ayaw niya maglabas ng signed affidavit. Ang ginawa niya, sabi niya, after I give it to the ombudsman, doon ko lang ibibigay. So yung lumabas ngayon, yun
Sinabit
na
sa
yun.
ombudsman.
Ang sinabi ni Atty. Baligod, yung kay Dilima kasi nakalagay na congresswoman. Hindi naman sa congresswoman nung binigyan siya ng pera. So, maganda yan para ina-address natin yung issue, magtawag sila ng formal hearing, magsasalita yung mga sundalo. Kasi alam mo, madaming mga tumatawag sa akin mga congressmen na nagsasabi, nagtatanong, ano ba yung sinabi? Wala talaga akong alam. Now, pag
Yes,
tinanong
sir.
ko kunyari, I will not name the particular person, sinabi ko, sinabi totoo ba itong nabigyan ninyo ng ganito? Totoo daw. Nakita nila, pumasok doon sa town hall, sila yung nagdala ng envelope. So maganda yan, maghaharapan. So sasabihin nila, nakita ka namin, nung araw na to, ikaw nagbigay.
Pero sir, yun pa lang
Congressman.
meron kayong sinasabing may alam kayo na wala doon sa affidavit. Kasi ito, sinasabi nyo, binigyan ng pera si De Lima nung hindi pa siya congressman. That's not even in the, that's not even in the affidavit.
No. I'm clarifying. Ang sabi kasi na Atty. Levy, ang mistake niya doon ng oversight, inilista niya na yung mga congressmen na binigyan.
Aha.
So sabi niya, nung panahon doon na binigyan, hindi congresswoman si Atty. De Lima. That's why he was saying, na totoo yun. Pero nagkamali ang oversight ko na
Hindi
inilista
siya
ko siya as
congresswoman pa.
congresswomen. Oo.
At hindi rin maleta.
Yes. I can check the affidavit now. I have a copy, but I don't think na maleta yung sinabi kundi envelope.
No, sir, sa affidavit
paano naging
maleta, sir,
envelope?
nakalagay.
Hindi, una it
She's
was,
in
teka lang.
the list of the maleta people.
Una sabi niya maleta, then naging paper bag, and now you're saying it's envelope. Ano po ba talaga, sir?
No. There's walang debate sa mga yan because this is not coming from me nor Atty. Levy. So I'm opening my cell phone now. I have here the files. I will particularly read yung instance kay Dima. So wala akong ano yan eh. Walang ibig ko sabihin hindi kailangan magdebate diyan dahil nakapirma na yan, na-notarize na po yan.
Okay, so if you could just let us know, ano ba?
Congressman,
Go ahead, Ami.
Congressman, itatanong ko lang kasi naguguluhan din kami. Ito bang mga payoff na to are linked to the ICC or to the flood control issue, yung mga payoff na yan? Kasi nabanggit nyo rin na continuation to ng testimony ni Orly Gutesa na nawawala ngayon, di natin alam kung nasan. But Orly Gutesa was testifying about flood control. He was not testifying about the ICC. Ano ba tong pinagte-testify ng mga etong latest na to, tong press conference? Are we talking about the flood control o yung ICC investigation kay President Duterte?
Yes, ma'am. Ma'am, thank you for the question. Actually, ma'am, nung nandun po si Gutesa, wala naman po siya, ma'am, na banggit. It was the flood control scandal yung investigation, but he mentioned the delivery of money. Ngayon po, dito sa mga sundalo, hindi ko nga po alam particularly kung anong issue po dito, kung ito po ay particularly linked to a particular project, linked to a particular, kunyari po, ICC. Yun lang po, ang batayan lang po talaga natin would be the timeline that they mentioned all these things. So yung ICC po malinaw, pero yung mga delivery ng envelopes and maletas of money, wala pong particular na issue or particular situation that they were discussing except yun din po pala sa sa Quadcom and dun po sa ma'am, yung isa pang issue was the Quadcom and the impeachment, yun.
Kasi ang insinuation, yung flood control corruption money was used for the effort to investigate Rodrigo Duterte para ibigay siya sa ICC. Yun yung insinuation eh. So pero hindi malinaw yun. Yung ba yung ini-insinuate dyan sa testimony ng mga yan?
I would think, ma'am, ang klaro dun sa issue nila is the three issues of the ICC, the Quadcom, at yung pong impeachment hearing. Yung pong mga delivery ng pera na iba, ma'am, ang sinabi nung sundalong isa, sabi niya, na-realize lang namin na kasi ma'am, ang kwento nila, 100 times po silang nagdi-deliver ng pera if they will add it all up. So it would be all of these issues, ma'am. It can be flood control, it can be the irrigation, ganun po.
So lahat na ng issues.
So belated realization na yung palang binibigay nilang mga mali-maletang pera na sabit dyan sa flood control corruption, ginamit din doon sa pag-iimbestiga ng ICC. Ganun ba yung takbo noon? Kasi hindi malinaw yung context ng press conference na yun eh.
Well, actually, ma'am, kasi ang problema, ma'am, sa mga sundalo, and to be fair to them, nagdi-deliver
Yes.
po sila ng pera.
Taga-deliver lang sila. Oo.
Opo. Ang makakaalam po talaga would be Saldico, Mark Tiksay, and Paul Estrada. Because they're the ones who know where the money came from at kung sino ang didilibera ng pera. So I would think, ma'am, na talagang kailangan magdikit-dikit yung issue niya because hindi naman po eksakto na alam na sundalo kung sino at saan ang galing yung mga perang ito.
Okay. I just have to say at this point, Ed Lingao has to step out because he's doing another show. Pero
Yeah.
there's still a lot of things that are not clear to us, Congressman. But you know, many of the people that that was named in the affidavit, have all vehemently denied it. Chief of them, yung Marines, na nagsabi na actually two of the gentlemen presented were not even part of the Marines, and most of them were dishonorably discharged. And then pati na rin yung ICC at this point has issued a statement saying they conduct investigations independently using their own budget, and it's all very transparent. And you know, it's not usual. We were saying earlier, it's not usual for the ICC to go so far as to issue a statement. But sabi nga ng reporter namin doon, they've been bombarded by questions from the Filipino journalists.
Ako, Regina, napakaganda niyan. Kasi kung i-confront nila yung mga issue, maganda nga imbestigahan nila na lalong malalim. That's why Attorney Baligod went to the Ombudsman. Ito, the soldiers are the ones who have personal knowledge of money being delivered. Thousands, billions of money. Sorry, not thousands. Billions of money being delivered. Ang sabi nila nung nakausap ko yung isa, minimum is 500 million, maximum is about 3 to 4 billion per delivery. And that's about 3 times a week. Paano itong perang to galing kay Saldico, saan ang galing? Now you have the flood control ghost deliveries na nakita natin.
Sir,
They
you're
were
not
talking about delivery. Yeah. No, let me just finish about it. So if we cannot blame the soldiers and say, anong issue mo?
No,
Galing
we're not.
ba yan sa quad
Okay,
hearing?
we're
Galing
not
ba yan sa-
blaming.
let me just...
There's no one blaming the soldiers.
All these questions that are being asked should be addressed.
No,
Kasi
sir.
sabi dito,
Okay.
sabi ng sindikato, kami yung mga nagnanakaw kami, akyat bahay kami. Ngayon, itong pera na to, kinukuha namin, dinideliver namin dito. So, hindi sila yung mastermind.
Okay,
They're
sir.
not part of the actual thing.
No one, to be
Yeah.
very clear, no one is accusing the soldiers at this point. All I'm saying is they are being discredited. Okay, the Philippine Marines themselves said most of them are dishonorably discharged. So it speaks to their credibility. Just like last time that you guessed it on our show, you said Orly Guteza was at the Marines compound, and the next day the Marines told us that that is 100% not true. That he was never there.
I would still insist, Regina. You see, you're taking their side. You're not interviewing me.
No, it's.
I'm still insisting. Oh, okay, let me explain. I'm still insisting that Guteza is with the Marines. Now he's not anymore. At the time, when I said he was with the Marines, he was with the Marines. I'm saying now that these soldiers are telling the truth. It is a corroboration of Guteza. It is a corroboration of Saldico. May delivery ng pera. Now, the Navy, I don't even think should react. What's the point? It's not a military operation. These are retired people that are already civilians. Ang sinasabi ng mga tao, nagdi-deliver kami ng pera, di ba dapat interest ng gobyerno, interest ng media, at interest ng bayan na malaman ang katotohanan dito? Kung nagsisinungaling itong mga taong to, so be it. Sabihin nyo, nagsisinungaling, may pagkakamali, pero may pera talaga nag-deliver, hindi ito kumita, and they are saying that this thing happened and we have to fight on it.
Sir, even back then, the Marines said it's what you were saying was not true. I spoke to Captain Marisa Martinez myself. She said there was no way that they could have smuggled someone like him inside the compound. Yun yung sabi niya.
Okay, if they're saying that, I think it's immaterial if they're saying that. Okay, I'm saying, okay, tapos na ang issue. I already acknowledged. Guteza already made a affidavit na dininay niya na lahat, and they even took a video of it. I'm already saying that. The affidavit that he mentioned in the Senate has already been altered, has already been amended. Tapos na yung issue na yun. Now you have soldiers again talking about it.
Congressman, alam niyo ba kung nasa na si Orly Guteza? Kasi everyone's looking for him. Hindi malaman kung nasa na siya.
Actually, ma'am, narinig ko po nitong maybe 2-3 weeks ago. Meron na namang naka-access sa kanya. He's okay. He's much, much better than what
He's alive,
happened before. Yes, ma'am. He's alive and the family is safe. Nung nawala po kasi siya, we immediately took the family, yung mga kasama na, not directly, I'm not personally involved, but I told those helping na itago na natin. So sa ngayon, ma'am, the message I got was he's okay. He's alive and he's okay.
Is he overseas?
Pardon?
Is he overseas? He's abroad now?
I'm not sure, honestly.
Okay. We were also getting reports of that, but we'd love to talk to you more about this, but unfortunately we have to cut this now because we have to cover the ICC confirmation of charges hearing, so I'll end it there. Thank you so much for talking to us today. That was former Congressman Mike Defensor. Salamat, sir.
Thank you, Congressman.
Okay, unfortunately, that's all the time we have for today. Thanks for joining Storycon. I'm Ipamidon, Editor-in-Chief of the Philippine Star. Join us again tomorrow, 4 p.m. for Storycon. I'm Regina Lay, and as I said, please stay tuned to this channel because we are carrying the continuing coverage of the Duterte confirmation of charges hearing. Kapatid, we are one news, all sides, all the time. Thanks for watching.
This is the Story Conference Group or the Storycon Group.
The historic legal battle of former President Rodrigo Duterte at the International Criminal Court continues today. We'll be giving you the latest as the hearing unfolds. I'm Regina Lay, and this is Duterte's ICC confirmation of charges hearing, a special coverage. We begin this special coverage with updates on the ground. We've got our reporter, Angela Lagunzad Castro, joins us live from The Hague. I just spoke to her a few minutes ago, but this is getting too close now to, the confirmation of charges, day 3 would have started already. Angela, how is it going so far?
Yes, Regina? Yeah. All right. So katatapos ko lang galing ako sa baba, no. Ongoing pa rin yung ongoing pa rin yung confirmation of charges. Nag-start na nga na magsalita ang defense, nanguna dyan, of course, si Attorney Kaufman ng legal defense ni Pangulong Rodrigo Duterte. And of course, he started his speech by making a general comment addressing, of course, the mainstream media reporting the case, and sabi niya, I hope they comment on yung mga comment daw na lumalabas. He reiterated na sabi niya, whatever it is na mangyayari today, sabi niya, does not regret or neglect any of the deceased or the victims in any case dito sa kaso na to. So he addressed practically he addressed sorry, maingay dito he practically addressed the victims before moving on to the merits of the case. At kasi parang sinasabi niya, it has been request, parang nakikita sa media na parang iba yung mga messages na iba yung mga messages na nakikita sa media regarding, pero ni-reiterate niya yon na hindi niya binabaliwala ang mga buhay na nawala in this case.
I mean, he did say that already on day 1, diba, Ange, when he mentioned that he feels that it's the media that's sensationalizing this story. But Ange, we'll leave that there for now because the actual hearing has started. We'll dip into the live feed now, but I'll get back to you later on once the hearing gets underway.
Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman, good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade Your Honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So the police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the deputy prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, but if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility. Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger. And you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had the speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument, because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, For this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pre-trial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? it was not as if it had been denied the arrest warrant for al-Hishri that it had sought? Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in al-Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the al-Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you. It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorising an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period. Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the Pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defence has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in a document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty which reaches more than a substantial degree of certainty is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Another one. Interviewee, at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer, yes, sir. Interviewer 1, okay. And on those 10 occasions, was the shooting justified? Interviewee, yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one, witnesses who said, the PNP never said kill those people. Another quote, from what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Dev Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
We lost the feed there for a little bit. That was, of course, defense counsel, lead counsel, I should say, Attorney Nicholas Kaufman, during the defense's submissions on the merits of the case. Just to quickly recap, Attorney Kaufman opened with a personal appeal, which is to say that he asked the Philippine journalists, all the media that's covering this case from the Philippines, to not focus on to make sure that we make clear that they are not making light of the loss of life in the war on drugs, and to focus instead on the case itself. Attorney Kaufman had said that the suggestion that the president, that Duterte, was the one who was responsible for all of these crimes was incomprehensible. He said the suggestion that that is possible is incomprehensible because this is a president that loved the people, including the majority that voted him into power. He said that the prosecutor's defense can't show that there is a single connecting line from the top down to the co-perpetrators down to the victims on the ground, and that is the crux of this confirmation of charges hearing. Attorney Kaufman said that there is no smoking gun in this case, not one demonstrable incident showing that there was a direct order in any of the 49 incidents that that the prosecution has presented. We lost the feed for just a little bit there, so what we're showing you right now is a file, but there is about 12 minutes to go still for this session for the defense to make its argument in the submission of the on the merits of the case, to make its submissions on the merits of the case. Going back to what Attorney Kaufman said earlier in his opening remarks, he said that insinuated that part of the problem may have been Philippine media, wherein journalists, he said, have a tendency to fixate on the salacious parts of a person's speech while ignoring the more boring parts. Relying on Duterte's speeches to prove criminal intent is impossible, he says. So he's basically discrediting much of the backbone of the argument of the prosecution, that because Duterte had said to neutralize suspects so many times in his speeches that translated to actual killings on the ground. He said that he qualified Duterte's speeches by saying that what the former president really meant, and which he sometimes did include in his speeches, was that the police officers can kill if their life is in danger. And that is a qualifier that Attorney Nicholas Kaufman kept coming back to, saying that it wasn't an order to kill suspects on sight or right off the bat, but it was an order to kill if the police officers' lives were in danger, were ever put in danger. The fact that the officers took the phrase to neutralize to mean to kill should not be Duterte should not be made responsible for that because that is their own interpretation. And basically, again, we are watching the first part of Attorney Kaufman, the lead counsel for Duterte, give his arguments on the submission of the merits of the case. This is just the first part. Tonight, there will be three parts to this. And I think we have the line now, so let's tune back in.
Ronald De La Rosa, Bato, as the Chief of Philippine National Police, De La Rosa issued a pre-drafted command circular number 16 of 2016 on 1st of July of that year, formally launching the anti-illegal drugs campaign nationwide in express pursuance of Duterte's campaign promises. There is no dispute that CMC number 16 of 2016 mentions Project Double Barrel, which was indeed modelled after Davao City's policing strategy and was directed at the neutralization of illegal drug personalities nationwide. But here we come to the crux of the prosecution case. The manifestation of the criminal plan in writing. Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald De La Rosa, Bato, within a day or two of him being appointed the Chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, Maître, je vous remercie, Captain, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
Again, that was the first part of day 3 of Rodrigo Duterte's confirmation of charges hearing. Today on the schedule, as you heard, it was the turn for the defense. They had their submissions on the merits of the case. And of course, the person you heard speaking just then was Attorney Nicholas Kaufman, the lead counsel of former President Duterte. Not much more different from this last part when he said he gave as evidence, he's rather submitted as evidence, conversations between Duterte and I believe some police officers, wherein he said, "We will make sure police procedures are being followed in every legitimate police operations. When they see that the police are really determined to go after them, legally, that word legally appears twice, maybe they'll get scared." And there was Attorney Kaufman making the case that, again, it was not Duterte's directive for the police officers to kill directly. It was only that they can kill or that they can shoot suspects if their own lives are in danger. The term to neutralize was never meant to kill, is the case that Attorney Kaufman was trying to make there. To help us break down what's happening with that first part, let's bring in our first guest now. We're talking to Attorney Ruben Carranza, Senior Expert at the International Center for Transitional Justice. Attorney Carranza, thanks so much for being with us. If you are still in New York, then it will be very early your time. Thanks for making time.
You're welcome. Happy to be here.
Okay. You obviously watched that submission on the merits of the case from Attorney Nicholas Kaufman. What were your big takeaways? What did you think?
There was nothing unexpected or even innovative about his presentation. Remember, this is the presentation on the merits, so this is supposed to be in contrast to the opening statement that he made, and so that the expectation should have been that the presentation that he made today on the merits fleshes out and expands on the opening statement. Unfortunately, the defenses he raises are predictably the excuses that Rodrigo Duterte and his co-perpetrators have already stated elsewhere outside of the ICC. But on the other hand, that is understandable because the presumption of innocence means that he need not lay out an explanation for why thousands of people died. But one key thing, he said that the statements of the criminal cooperating witness, in other words, the insider witness that he keeps quoting, together with the statements of Rodrigo Duterte that were also used by the prosecution, he said that these are circumstantial. And he did acknowledge that circumstantial evidence is has been used at the ICC in previous cases. Jean-Pierre Bemba, Tomas Lubanga. So, the first case, as well as one of the more recent cases in which, in fact, Kaufman was the lawyer for Jean-Pierre Bemba initially. He did acknowledge that in those cases, the ICC, the trial chamber, accepted circumstantial evidence, but he says that circumstantial evidence in this case, he claims is low quality and that there are other conclusions that can be made from the circumstances. I don't know if he will address it in the resumption of this presentation, but the problem is that his problem in defending Duterte is that the outcome is thousands of murders. So you might have other conclusions. They were joking, they were instilling fear, they were planning something else, but then the outcome is thousands of murders. So that, I think, weakens his argument that there are other possible conclusions to make out of these statements.
So his defense, at least in this first part, was predictable and nothing came as a surprise to you. But one thing that struck me is when he said there is no smoking gun in this case. There is not one demonstrable incident that shows that there was direct orders to kill in all of the 49 incidents that the prosecution is using in this case. What did you think of that? I thought that was pretty powerful to say, because that is exactly the question that we're trying to answer here, right? Is there enough grounds? Is there substantial grounds to move this case to trial?
He did sort of make his own interpretation of the persons watching now should remember the characterization of Rodrigo Duterte here is indirect co-perpetrator, which means there are direct co-perpetrators. And as Kaufman mentions it, the ICC uses different modes of liability, meaning different theories of how persons can become criminally liable, can be convicted, can be found guilty. And one of them is the concept of indirect co-perpetration. There are others, and maybe not now is not the time to do it, but joint criminal enterprise, command responsibility. So there are various other theories, modes of liability that the ICC and other international criminal tribunals have used in the past. One of the important elements of indirect co-perpetration as a mode of liability, as a way of convicting a person, is that there is a common plan. And Kaufman acknowledges that there is, the prosecution has tried to prove that element here. But one of the other important elements is that the direct co-perpetrators, including insider witnesses, including policemen below the other co-perpetrators, the other indirect co-perpetrators, that these are tools, they are weapons, they are ways of accomplishing the criminal common plan. And that's the problem here when he says that that there is no smoking gun. There is no smoking gun with respect to Rodrigo Duterte. Why? Because he is an indirect co-perpetrator. There is a smoking gun with respect to those who actually carried out the killings. There is a literal gun in many of these instances, and he then cites statements that say, we found guns, for instance, according to an insider witness. And of course, those quotes that he makes are extracted from the overall interviews. And so the ICC judges will, I am sure, look at the entirety of the interviews conducted by the ICC investigators and used by the prosecution, to which everyone has access, by the way, the defense, the prosecutors, obviously, and the judges. But that's the incomplete aspect of Kaufman's argument. There is no smoking gun with respect to Rodrigo Duterte because Rodrigo Duterte is an indirect co-perpetrator. I won't say only, because an indirect co-perpetrator is just as guilty as the direct co-perpetrator in this theory, in this mode of liability concept.
Okay, so you can convict a person based on circumstantial evidence, and there's no smoking gun in this case because he's being charged as an indirect co-perpetrator. Is that a lesser crime than, I suppose, a direct perpetrator?
No, it's the same level of liability. He's a principal. I'm trying as hard as I can not to be a lawyer in terms of the language I use here. So he is as guilty as those who shoot and kill. He is as guilty as those who ride motorcycles in tandem and assassinate people who were killed in the drug war. Let us not be misled by the term indirect, because indirect does not lessen liability. Indirect, the use of the word does not mean he is less guilty. If there were to be a hierarchy of guilt, then you could even argue that it should be from the top going down. But the value of this concept of indirect co-perpetrator and direct co-perpetrators executing a common plan is that it's both the conduct, even words, even statements made by the indirect co-perpetrator linked to the outcome, to the conduct, actions, not necessarily words of the direct co-perpetrators, that manifests, that shows that there existed or exists a common plan, and in this case, a common plan to commit crimes against humanity of murder. So like I said, when Kaufman denies that they had a common plan, when Kaufman denies that there is a smoking gun that can be traced to Rodrigo Duterte, he doesn't account for the fact that thousands of people were then murdered by... If these elements were not connected, Duterte's statements, Bato de la Rosa's own statements, the actions of police, some of them identified, some of them unidentified, that then results in thousands of murders. Are they random? Are they unorganized killings that only happen to take place within a span of a few months to 2 years? They have never happened before in the Philippines. And if they did happen before, they happened in Davao, which, by the way, is part of the initial set of charges.
Yeah.
So there's only one inference you can make from that.
Well, I'll leave that to the judge, sir. Pero the point that he was trying to drive at, I guess, is clear. He was trying to cast doubt on that causal link between the speeches and the killings. In his opening remarks, he said, part of the problem, and I'm paraphrasing here, part of the problem is that the Philippine media, the journalists here tend to fixate on the salacious parts of a person's speech and leave out the boring parts. That was pretty accurate in terms of is the wording. And he says that relying on the speeches to prove criminal intent is impossible here. What did you think?
No one will ever, unless there's somebody perhaps as convinced of his impunity as Rodrigo Duterte, no one ever comes close to saying, I will, as a government official, I will now order other government officials to commit crimes. That isn't not only not normal, but that isn't how crimes are committed. And even if, as I said, in the case of Rodrigo Duterte, he came close, and not even close, but sometimes actually crossed the boundary between saying something and commanding the commission of the crime. The excuse that he also, in some of his statements, qualified those words with words such as "but follow the rules," or as Kaufman cites here, the memo that was issued by Rodrigo Duterte's government says respect human rights.
Yes.
Those qualifications don't even have to be said. The fact that you say them in a document, even if you did not have to say them, because obviously government officials, the police, are supposed to follow human rights. If you have to put that in a document, if you have to put that in a memorandum called Oplan Double Barrel, that means you are trying to cover up their violations of human rights, because there is no reason, unless you're the Commission of Human Rights, in which case that's your mandate. You say it and you specify it, but there is no reason really to have to say that unless it was something you already had in mind to use later on as an excuse, as a defense, which unsurprisingly Duterte himself also says. He says, I will protect you. He says, I could even pardon you. He says, I will make sure you are not prosecuted. And that's how he does it, by coming up, for example, with a memorandum that says, you do this. He doesn't say kill. He says neutralize. He doesn't say commit mass murder. He says carry out operations. Because nobody will say in a memo carry out mass murder. Nobody says in a memo kill 1,000, 2,000, 5,000 persons. And again, it goes back to the same question that Kaufman did not address. Why did all of these memos, all of these statements, then were followed by thousands of people killed?
But yun nga, sir, towards the latter part of his argument, Attorney Kaufman was saying the fact that some police officers took to neutralize to mean to kill should not be on Duterte, because he didn't actually say that explicitly. But I guess what you're saying is, there is some sort of a causality there as well, and it's up to the prosecution to prove.
And something to also link to this defense. Neutralize did not mean kill. Duterte did not say that for policemen to interpret it as killing. It's a similar question, really. How does he explain why thousands of people were killed after the word neutralize was used? That is an example of circumstantial evidence. The ICC in past cases, Katanga case, a warlord in the Democratic Republic of the Congo claims he did not issue similar explicit orders, but that his subordinates killed people anyway. In that case, the ICC in fact said that the prosecutor and later on trial judges, if they convict the accused person, that they do not have to explain their logic every step of the way. They do not have to painstakingly explain why they arrived at a certain conclusion. Why? Because inferences are possible. The human brain is capable of sorting through and filtering among different possibilities connected with a term, a set of words, a piece of paper that can be interpreted in different ways, but that if you take all the circumstances together, and an inference is possible, and though no other inferences might be made that explain it, then that can be the basis of a conviction. So, neutralized, and this is the other point here, within the context of the Philippines, neutralize has been applied by law enforcement agencies in the Philippines, not just the police, but even the military, to mean to kill. Kaufman has been fond of excusing Duterte's speeches and conduct as part of the culture. Many of Duterte's own mouthpieces are fond of excusing him by saying he's just Bisaya, he's just speaking in his language.
Bluster.
Back in Davao. I grew up in Cebu, and I know I speak the language and I understand the context. And so I know what persons who use the language mean when they say something in place of something else. And that's exactly what Duterte is doing here. The swagger, the language, both the body language and the actual words, including in Bisaya, are meant to neutralize the term that policemen in Davao, not just later on, not just nationwide, but in Davao, who understand the same language, who literally speak the same language, they knew neutralize in Bisaya would be pumatay. So you cannot have you cannot have one interpretation and say he was just joking, he wasn't serious, and then on the other hand say don't take it out of context. You cannot say don't take his jokes out of context in one hand and then say here take it for the context it is in.
The word that he often uses is bluster. It's just bluster. And you're right, in local context, the word neutralize has always been used in police operations, even way before the war on drugs. But I get your point. Inferences are what it's going to come down to. Inferences are possible. We'll leave that there for now. We'll circle back to you a bit later on in the program. We do have a 4-hour stretch here. But thank you so much for talking to me, Attorney Ruben Carranza, Senior Expert at the International Center for Transitional Justice. We'll come back to you.
You're welcome.
At this point, we're going to get more reactions, this time from a so-called Duterte ally. Joining us is former PDP Laban senatorial candidate, Attorney Jimmy Bondoc. Attorney, good to see you again.
Good evening, ma'am, and thank you for having me. I apologize for my current circumstances. Now I'm in transit.
Oo nga, mukhang you're in the car.
Yes, but I couldn't pass up the chance to talk to you and to at least represent an alternative point of view.
Thank you for taking our call, and that's exactly what we want to get at, which is the alternative point of view here. I don't know how much of what Attorney Carranza's perspective you heard, but I guess you heard towards the end what he thought about the argument that to neutralize. The fact that it was was interpreted as to kill should not be on former President Duterte. In any case, what did you think of the defense's first part of the submission on the merits of the case?
I was more pleased about today. Well, the first day was good enough for me. I think Kaufman did a good job. But the difference is that today I was very happy to hear about his emphasis on the issue on jurisdiction, because I really think that is something that we have to ask before we argue about law and before we argue about guilt or innocence. I think we have to be candid about the first aspect, which is there's a question that we all have to ask. No, are we still capable of judging ourselves as a nation? No, because I think the outsourcing of justice is a very dangerous precedent, and this will be very damaging to our sovereignty. Now, Nicholas Kaufman finally addressed the issue on why did the ICC take 4 years not to initiate the investigation. And I think that is something that is worth waiting for an answer towards, no? Because the Nicholas Kaufman astutely points out that the prosecution did not initiate within the 1 year withdrawal period. So aside from that, I think the other arguments of Nicholas Kaufman were expounding on in his initial arguments that they do not have direct evidence.
Yeah.
And he was finally he is looking for a causal nexus, which I think all lawyers and even laymen should be able to appreciate. No? Because we if we talk about Duterte only, this will be very polarizing. But we should be talking about the basic tenets of the law.
Attorney Bondok, pasensya na, but I have to counter you a bit there. They did not talk about jurisdiction today. In fact, Attorney Nicholas Kaufman basically spent most of his time in this first part of day 3 of the confirmation of charges hearing trying to cast doubt on the direct causal link between Duterte's speeches and the killing. So wala pong napag-usapan na jurisdiction today.
No,
that was in previous days.
I beg to disagree, ma'am. No, they did not mention the word jurisdiction, but he finally brought up the fact that the ICC took 4 years before initiating.
Yung delay.
And according to the Rome Statute, no, if it is not initiated and referred to the office of the prosecutor within that year and within the time that we are still parties to the Rome Statutes, then they do not have jurisdiction. So the lack of or the absence of the mention of the word jurisdiction does not mean that he did not bring it up. He actually brought up or laid the predicate. He laid the predicate, no, of the argument of jurisdiction.
So it was just a peripheral mention, but again, he spent most of his time at the start.
That's not. Yeah, that's the very core of jurisdiction.
Yeah,
In fact, the argument of the Duterte allies, no, is really because it was not initiated within the withdrawal period.
Yes, yeah, I understand. I understand, sir. But I watched the whole thing, and he only touched on it very briefly. The bulk of the presentation was about the causal link nga between the speeches and the killings. But anyways,
I agree with that. I agree with that.
Yeah, so yun nga, I mean, I listened to the whole thing. But anyways, since you brought up the issue of jurisdiction, the thing is that the pre-trial chamber already decided on that. I know it's in appeal, pero in October of 23 of last year, they already issued a formal decision on the jurisdiction challenge, saying that because we were bound by the Rome Statute from 2011 to March 16, 2019, they can investigate crimes that happened during that period. Of course, after March 17, 2019, they couldn't anymore, but they already issued a decision on that. And I know that the defense is filing an appeal, but the appeals court hasn't issued a stay on the confirmation of charges hearing, which people are taking to mean that, okay, proceed with the confirmation of charges, proceed with the timeline, right? What would you have to say to that?
Well, of course, we are powerless against that. No, the Latin maxim comes to mind. No, yung who will police the police, or qui custodiet ipsos custodes. No, kasi there is I don't think there is any court or a foreign court in this world that will say, oo nga, no, wala kaming jurisdiction. Because that is something that our nation should be fighting for. No, that we should be creating global awareness about. Which is why I started with a question that are we still capable of judging ourselves as a nation? Do we have a functioning judiciary, or are we beginning to outsource even our judicial processes? Now, I know this really sounds like a Duterte fanatic. I know the bashers will be, chomping at the bits, no? But this is a true, sincere question from me, because it will really set a bad precedent. I have been placed on record as stating that even after this administration, if someone from our side, let's just call it our side, no? If someone from our side tries to outsource justice to the ICC or to another foreign body for a local perpetrator, I will be against it. I will go against it, because I think Filipinos accused abroad or wherever should be tried here on the basis of territoriality.
Attorney, did you watch the whole session kanina?
Yes, I think I caught most of Kaufman's defense.
Okay.
All of it.
He showed
Kaufman.
a slide kasi The title is Anti-Drug Operations from, I don't know if we have that, but if we have, let's flash it. Anti-Drug Operations from July 1, 2016 to February 8, 2019. 3 bars. First bar, drug personalities arrested, 176,021. Second bar, anti-drug operations conducted, 123,441. And finally, third bar, deaths in operation, which is 5,281. Ito na yung medyo confusing because, of course, people have different numbers. Yung official police record was about 6,000 deaths during that time. Amnesty International and other human rights organizations peg it at closer to 30,000. But here is another number today, 5,281. Even though it's smaller than some of the figures being thrown around, that is still 5,000 deaths, no? How do we argue around that?
Two things, no? First of all, we're talking about 49 incidents right here that are mentioned in this case. 49 incidents are the ones that they are showing direct proof for. So we should lay down the parameters to be fair. We are talking about 49 incidents, meaning they have perhaps not enough evidence or even probable cause to even talk about the 5,000. So why are we mentioning the 5,000? No, but I think Kaufman made a good argument, stating that there is no smoking gun. No? That they are not citing any direct evidence that PRRD or former President Duterte by direct order asked for these killings to occur. No, so the numbers get confusing only if we mention statistics when it is convenient, no? But the numbers are already here. It's 49, and the reason why I like this is because Attorney Kaufman finally mentioned the elements of crimes against humanity, and the two basic ones are there should be a widespread systematic attack and that it's directed at the civilian population. Now, I don't want to bore your viewers, ma'am, but it's good that he finally defined the legal international definition of what a civilian population is, as opposed to a subjective subgroup. And in this case, and he cited the El Hisri case, no, the Khaled Mohammed El Hisri precedent, that there an attack on a clearly defined civilian population versus a subjective subgroup, no, and that the attack, so-called attack or the enforcement against the drug pushers were not considered a civilian population, but rather a subgroup that was perceived by expert police or with expertise to separate them from the population. So there's no attack on the civilian population. And again, this is just clarifying what Attorney Kaufman argued.
I'm not sure if he's disputing that there was an attack on the civilian population. He doesn't dispute the deaths. He disputes the common plan that the prosecution said. Prosecution said there was a common plan to attack the civilian population. But he acknowledges that there were deaths. And also, Attorney, let me just set the record straight. 49 incidents doesn't mean 49 people dead. It means 49... there were 76 victims of murder and 2 of attempted murder. And of course, we know that this figure, 49, is just a representative sample of the cases. The trial court has also approved 539 other witnesses for this case. So, of course, in 49, I know what you're saying, but 49 here is not the extent of all the victims.
Considered, and I did not mean that. I'm just saying that the numbers are not clear because we're relying on multiple sources, and some media reports are still being quoted even though they are not part of the incidents mentioned. So I think we should even us, just among us, we should finally come to a certain number so that we can pursue the argument of whether it was a widespread attack and systemic attack against a civilian population.
So the breakdown of 49 is 14 Well, I'll get to it later, but there were, for 49 incidents, again, let me just repeat for those watching, 49 incidents doesn't mean 49 victims. 49 incidents covers 78 victims, 76 for murder, 2 of attempted murder. But at this point, Attorney Bondok, what are you hoping the outcome will be? I mean, of course, I know you're hoping that he will be exonerated and that this does not proceed to trial. But after having seen days 1 and 2, where the prosecution laid out a strong case, complete with pictures, videos, and so on, what are you just hoping for, best case scenario at this point?
Well, we can always hope against hope. Hope is different from what I predict, no? Of course, what I hope for is very obvious. We want the president here. And in fact, I'm not opposed to him being tried here because I would like his innocence or guilt to be tried by a local court. That's my hope, no? But my prediction is very bleak. And I think this is a irreversible damage to the Philippines, no, to the Philippines, and that's very hard to believe from me right now. Completely conceded, but I think somewhere down the line we will find ourselves agreeing on this point that this is a damaging turning point in our history as a sovereign nation.
What happened? Why is your prediction a lot more somber? Bakit? Anong nangyari, sir? That made you change?
It has always been that, no? Ever since he was taken to The Hague, I have been placed on record to have always predicted that we will be very lucky, fortunate if he is ever sent back here.
Are you by any chance in touch with any of the 6 Filipino lawyers that went there on behalf of the Duterte family? Baka may update ka din, sir.
Not currently. They're all my friends though, but not currently.
Okay, because we're also wondering. Our reporter there was had spent a bit of time with them yesterday, and we understand that Attorney Sal Panelo is applying to become ICC accredited.
Yes, accredited
through his son. But we're not sure when that application was filed, and when that outcome might be decided on. But let me pivot a little bit right now, since you said, okay, you're not very hopeful that that he will be sent back home. But can I just ask you a little bit about the impeachment, since you are identified as a so-called Duterte ally? I'm sure you have thoughts as well on what's going on right now.
It has taken on so many new facets. Ronnie Puno, of course, we've all heard about that, the NUP, no? And aside from that, this affidavit of the 18 ex-employees of Zaldico is sort of tied into this supposed quid pro quo undercurrents, no? I think the impeachment, ito mas hopeful ako. Mas hopeful ako that I think there will be an end to it soon, but I think I'm just being hopeful. But I really think that it has been affected by the pronouncement of the VP. That's one. Number 2, the seeming lack of enthusiasm from big players in Congress. And 3, I think the fatigue of the nation it's just very palpable. Everybody's just tired of impeachments.
Are you hearing from some insiders, sir, baka in terms of the appetite for Congress for another impeachment? Kasi we've also been asking a few of our sources. They do say that there is a little bit more hesitation this time around. But anyways, by the way, before you answer that, let me just correct the record as well. A hold of the Ombudsman and them weren't, apparently, according to the Philippine Navy.
Marines, some of them were not, some of them was saying that I think that's beside the point. No, doesn't matter if they were ex-Marines or whatever they were. They could have been whatever. What we need to prove is that they were indeed employees of Zaldico and that they had personal knowledge of the things that they have stated in the affidavit. I think that's all that matters. But again, I'm not saying that that's going to definitely affect the impeachment proceedings, but we're being pragmatic here. And what we're saying is it could affect the impeachment. Taken together with the pronouncement of the VP and the hesitation of the congressmen that we mutually know, and big people, big parties declaring that they are not in favor of impeachment, it truly lessens the weight or the fervor towards impeachment. Plus, again, the fatigue, the very palpable fatigue of the people.
Some critics say it's like a Damocles sword hanging over people's head in Congress, with the implicit,
a sword of Damocles.
Damocles, with the implicit message that be careful, if I win, then I'm going to remember who you guys are. Do you think that's accurate? That's what some of the critics are telling us.
I think there are two swords here. No, the impeachment has been a Damocles sword, the sword of Damocles over Sara, and then her pronouncement has just put up an active defense. So I think there's two swords here. But I think, kahit sino po ang magmarunong ngayon on the outcome of this will definitely be wrong, because there's just too much at play.
Okay, and then finally, Attorney Bondoc, just very quickly, are you running for office? There are rumors that you might be interested in a higher position, though.
No, I mean, I ran for the Senate, and I have been severely traumatized by that. No?
I remember we interviewed you during the campaign period.
Yes, which I still appreciate to this day, ma'am. And it's always an open. I'm not one of those people who would be coy and whatever, but I'm truly hesitant this time, and I must listen to the rumblings and to the politics now. But ultimately, I am not ashamed to say that I will wait for the not instructions, but the suggestions, of our dear Vice President Sara.
You're waiting for suggestions from her.
Yes, because that's the political aspect, and I don't hide these things. With her support, there's just an increased chance, no.
Meaning, if she tells you to run, then you say yes.
Yes, because the political capital is obviously with her, and I'm here to help through her. On my own, I don't think I have much political capital, to be quite frank.
Well, you're pretty influential online, but we shall leave that there. Thanks so much for talking to me again, Attorney Jimmy Bondoc, former senatorial
God
candidate.
bless everybody.
Salamat, sir.
Thank you.
Okay, we are now going to tune back in to the second part of today's confirmation of charges hearing against former President Rodrigo Duterte, again, still with the defense's submission on the merits of the case.
Implementation of Operation Double Barrel. The document also included an exhortation to monitor human rights violations perpetrated by PNP operating units. The term neutralization itself is, of course, not defined anywhere in any of these documents as meaning to kill, a point the prosecution itself conceded at that moment in time when it was seeking the opening of an investigation. And I refer, Your Honours, to ICC 01 on 21, document number 7. So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional. especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, Counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course.
Thank you very much.
I thought we had an understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing. But of course, the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 0000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out
We seem to have lost the line again. We're going to try to get back in, but the line is a little bit patchy. But of course, that was Attorney Nicholas Kaufman, lead defense counsel for former President Rodrigo Duterte. Today is day 3 of the confirmation of charges hearing. Today is the day that was given to the defense. What he was doing there was part 2 of the defense's submissions, I should say, on the merits of the case. As with the first part of today, Attorney Kaufman repeated some of the his arguments, which is to say, which is centered around the language, the terminologies that were used in during the time of the Duterte administration. He made the case that neutralization does not mean killing, which he has already said before. But again, he said neutralization in this instance only means self-defense if the police officers' lives are in danger, and it does not mean to kill outright. Neutralization, in the language of the legal documents, says that it may include capture, surrender, or other acts to subdue the suspect. All right, let's tune back in to catch the rest of his presentation.
Category of circumstantial proof for a common criminal plan. The prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In 2 government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law, unwritten proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible. But I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realise, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, three of whom supposedly formed the hardcore of a more limited organisation referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather
Welcome back. This is the special coverage of Duterte's confirmation of charges hearing at the International Criminal Court at The Hague in the Netherlands. Let's now tune back into the session. They just paused for a quick break, but we've got them back online now. Please take a listen.
Under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests. Prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006 0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.
There you have it. The second part of today's confirmation of charges hearing is over. That was Attorney Nicholas Kaufman, lead defense for the counsel, on his submission on his submissions, I should say, it's plural, on the merits of the case. As with the first part of today, he had made the argument that prosecutors were cherry-picking speeches done by former President Duterte, ignoring the ones of him, stressing that police officers need to act within the bounds of law. There were a few more slides and charts that he showed in the second part of the agenda. He, in fact, towards the end of this session, said that if prosecutors had also recreated the bar charts in the 2 years after former President Duterte stepped down, they would see that the number of killings remained high. And in fact, he said somewhat facetiously that they would run out of space on their computers. He ended by asking a question: has anyone thought to investigate the Marcos regime over these drug killings, these alleged drug killings as well, and why the victims are not clamoring for justice over those deaths, is what he said. Similar to this, that was the second part of his argument, but similar to the first part of today's session, he continued to poke holes at the causal nexus, what they call the causal nexus between Duterte's speeches and the killings on the ground. At one point in the first part, in the first session of today, Attorney Kaufman gave what I feel is the strongest argument yet by saying that there is no smoking gun in this case, and argued that there was not one demonstrable incident that will prove any of the 49 incidents that have been brought before them to this pre-trial chamber. Attorney Kaufman also at one point showed a graph that showed that he said showed that there were only 3% deaths out of thousands of police operations that were conducted during the Duterte administration. It was a pie chart with a very small sliver of red that he said, well, in comparison to the number of arrests and operations conducted, the number of deaths is minimal, he said. And if he can say the only thing that is widespread is the utility of the prosecution statistic, basically arguing that the prosecution used skewed statistics right there. Out of over 1,900 cases investigated, Kaufman said there were 300 police officers dismissed, some of whom were later convicted and sentenced to life. And he was decrying why the prosecution failed to mention those statistics in their submission on the merits of the case earlier this week. He said there were thousands of cases that were investigated, thousands of killings that were investigated under the Duterte administration, but were not mentioned by the prosecution. And that, he says, is far from being evidence to his evidence of his guilt here. That is testament to Duterte's respect for the rule of law and disdain for rotten police officers, is what Attorney Kaufman argued. And again, more bits about how the prosecutors were cherry-picking cases and cherry-picking videos in order to make the case that his speeches is what caused them to kill. There was much about the term neutralization once more. Attorney Kaufman once more made the case that it only means self-defense if the police officers' lives are in danger. He cited a legal document that said it may include capture, surrender, or other acts to subdue the suspect, but nowhere does it say that it means killing directly. He also questioned why, earlier in this program, the ICC prosecutors did not just save itself all of the hassle of its jurisdictional problem, a fundamental issue that still plagues it, by investigating the cases sooner, and why he was questioning the delay in the investigation of the deaths into the drug war. At this point, let us check in with News 5 Vigilante, Mac Ortiz, who's reporting to us live from The Hague. Mac, kamusta dyan? Anong reaction ng mga Duterte supporters dyan? Nakita ko nasa labas ka. Mac, naka-mute ka yata.
Yeah, thank you. Hindi na, andito tayo ngayon sa labas ng ICC compound, yung tinatawag nila na ICC steps. Andito rin nagtipon-tipon yung mga supporter ni former President Rodrigo Duterte. Tapos, ito ang bago dito ngayon, papakita ko lang sa'yo. Meron sila dito mga bagong painting. I-flip ko lang yung camera para makita nyo. Yan. Ito yung mga bagong painting yan dito. Yan. Standing the President. Then, okay. Then, ito yung mga supporters nila. Actually, maglalakad ako kasi alam ko, nakita ko si Atty. Salpanelo kumakain. Baka actually halos araw-araw na lang natin tinatanong si Atty. Sa ganitong oras habang kumakain. Pero kung ko siya ngayon Wait lang.
Ayun, mukhang maraming...
Ayan si Atty.
Ayun, mukhang maraming tao gusto makausap din siya.
Attorney Sal, Victor Bedulit kita. Si Regina po from
Hi.
One News.
Good afternoon, Attorney. Hello, good afternoon, Attorney. Just very quickly, kamusta naman po? What did you think of that of today so far?
Tinatanong ni Regina kung kumusta naman po daw today yung ganyan.
Maganda. Si Attorney Kaufman, study this case. Yeah, the thorough research on the speeches of the president, and as well as the documents. Kaya he was able to use it to rebut all the prosecution.
Sir, we heard that you're applying for ICC accreditation. Bakit po?
Attorney, pinapatanong ni kung you're applying daw for ano?
ICC accreditation.
ICC accreditation po.
Yeah.
Bakit po, sir?
Bakit daw po, sir, you're applying for it?
Makahanap tayo dyan para makatama makatulong kay Presidente.
Is there a plan to make you the lead counsel just in case ma-accredit po kayo?
Just now, sir, ma-accredit kayo. Are you applying for the lead counsel daw po, sir?
No. I'm just applying to be accredited so that I can appear.
Okay. Okay, salamat, sir. We'll leave you alone.
Again, more importantly, not to appear, but to visit the president.
Oo, inside.
You are not an accredited lawyer and member of the defense team. You can't visit him.
Inside the detention center.
Primary reason.
Okay, salamat, sir.
Pangatlong beses ko siya dinistorbo habang kumakain.
Okay,
Kaya,
thank you, Mac.
Okay. Sa ngayon, marami pa rin tao ngayon dito. Patuloy pa rin dumarami yung mga supporters ni former president. Andito tayo sa ICC steps. Tapos, kanina bago tayo mag-live, yung doon sa part parang lunchtime, doon kasi minsan nagitipon-tipon yung mga anti-Duterte supporters naman. And sa pagkakaalam ko, meron sila dito na candlelighting mamaya around 5 p.m. Yung muna latest dito, Regina.
Mac, anong sinasabi ng mga supporters sa'yo? Hopeful pa ba sila na hindi matutuloy sa trial itong kaso by the end of the week? I mean, of course, hindi pa magde-decide sila end of the week, pero what are they telling you?
Actually, marami tayong nakausap ng mga pro-Duterte supporters. Hati sila. Yung iba parang they're preparing for the worst daw, na just in case matuloy yung trial. Yung iba naman, hopeful pa rin na kumbaga, mapauwi si former president daw sa Pilipinas at doon daw litisin. Yun ang thoughts nila.
Meron pa rin, some of them are bracing for the worst, preparing for the worst. And then, Mac, lastly, kamusta naman yung crowds? Ngayon, mukhang ilan lang yung mga nasa likod mo. Kumunti ba today o mas marami ba noong Monday? Or pareho lang?
Nung Monday dito sa ICC, so mas marami sila. Yesterday, dahil walang ganap dito sa ICC, andun sila sa detention, doon sa tinatawag na Duterte Street.
Oo.
Yesterday, andun si former Executive Secretary Mijaldea, si former LTO Delgra, and si Attorney Sal Panelo. Marami dun kahapon dun sa may Duterte Street na tinatawag, like very festive kasi kumain sila ng gelato, flavored ata, pistachio and salted cream ice cream yung kinakain nila.
Ang sarap naman. Mac, nakausap mo ba this buong linggong to, may chance ba na nakausap mo si E.S. Mijaldea? Because siya naman talaga yung constant dito, yung kasama ni Duterte, simula pa lang na pinadala siya sa Hague, di ba? Nakausap mo ba si E.S. Mijaldea about it?
Nagkausap kay Executive Secretary ay si Angela. Siya yung nag-interview dun yesterday dun sa
Okay. So tawagan na lang namin si Angela mamaya. But and finally, kamusta naman dyan? Kamusta naman kayo dyan? I mean, dire-diretso kayo, no? Monday, simula ng Monday, Tuesday, tapos ngayon Thursday.
Yes.
Paano kayo, I mean, nakabantay lang kayo dyan sa labas, dire-diretso, no? Until matapos.
7 hours na backwards yung oras dyan sa Pilipinas. Kaya pag nag-morning show dyan, dito is like mga madaling araw. Medyo malamig. Yun yung struggle namin dito dahil nga Pilipino, di naman sanay sa malamig na klima. Kailangan namin magbalot talaga. Like, kahit pirik yung araw, talagang malamig talaga dito.
Oo nga, mukhang ginawa ka ba? Nakailang layers ka, Mac? Okay.
tatlong layers ako. Pag
Okay.
humahangin talagang malamig.
Hindi pwede magpalipad ng drone, no? Mac?
Actually, ayaw kong subukan. Baka kasi pag nagpalipad ako, yun na yung last na day ko dito. Baka i-deport agad ako sa Pilipinas.
Oo nga naman. Oo nga naman. You need a permit for that. Okay, iwan na natin na. Salamat. Thank you so much for your reporting. News 5 Vigilante, Mac Ortiz. Okay, well, let's now revisit the series of events that led Rodrigo Duterte, once dubbed the Punisher, into the hands of the International Criminal Court. Mobile journalist Amy Atienza has that story.
Rodrigo Roa Duterte. That's my first middle name is Roa. The surname is Duterte.
Now that Rodrigo Duterte is facing proceedings at the International Criminal Court, the question is, how did it all begin? The trail leads back to April 2017 at the height of his administration's war on drugs. Late lawyer Jude Josue Sabio filed a communication before the High Tribunal, accusing Duterte and several officials of crimes against humanity over alleged extrajudicial killings. Sabio represented self-confessed Davao Death Squad hitman Edgar Matobato. The filing relied on insider testimonies, human rights reports from Amnesty International and Human Rights Watch, documentation from church sources, as well as the media. In his letter to then ICC prosecutor Fatou Bensouda, Sabio argued that when a state fails to prosecute crimes against humanity within its own territory, the ICC must intervene. The complaint did not name Duterte alone. Several senior officials of his administration were also cited. More than a year after Sabio's complaint, families of drug war victims and activists brought their own complaint before the court, amplifying the call for international scrutiny. By then, ICC prosecutor Bensouda had already launched a preliminary examination into killings linked to Duterte's anti-drug campaign. But Duterte pushed back. In 2018, he announced the Philippines would withdraw from the Rome Statute, the treaty that established the ICC. The withdrawal took effect in March 2019. However, the High Tribunal retained jurisdiction over alleged crimes committed while the country was still a member, from November 1, 2011 to March 16, 2019. That period covered Duterte's final years as Davao mayor and his presidency. But even as the legal process moved forward, the former president publicly criticized the ICC.
For the things that I have said, ordered, and done, I am willing to put my neck dito sa mga bagay na to. Baka balang araw, itong ICC na itong bugok na to, if they decide to hang me, I would be very glad to go.
Still, the case advanced. In September 2021, ICC judges authorized a full investigation. The Philippine government appealed, arguing the court no longer had authority. But in July 2023, the appeals chamber rejected that argument, allowing the probe to resume. Then came the turning point. In early March 2025, ICC judges issued an arrest warrant under seal, accusing Duterte of crimes against humanity, specifically murder, linked to drug war killings. On March 11, after returning from Hong Kong, Duterte was arrested in Manila and flown to The Hague. He was formally turned over to the ICC the following day. The charges later evolved. What began as one count of murder covering 43 incidents was revised to 3 counts of murder involving 49 incidents and 78 alleged victims. Among them was teenager Kian de los Santos, whose killing sparked nationwide outrage, along with several individuals tagged as high-value targets. At the core of the case is a fundamental question, not simply whether individual killings occurred, but whether there was a policy behind them. Now, nearly a year after his arrest, and even as he opted not to personally attend the hearings, Duterte remains under ICC detention, awaiting the judge's decision on whether the case will proceed to trial. Kapatid Amy Atienza, we are One News.
Which brings us to today, day 3 of the confirmation of charges hearing for former President Rodrigo Duterte. Let's now get some more reactions This time back to the side of Duterte's supporters. Joining us right now is former chairman of the Presidential Anti-Corruption Commissioner, PAOK, Greco Bellica. Good evening to you, sir.
Hi, good evening, ma'am, and good evening to all our viewers and listener. It's PACC, ma'am, not PAOK. I'm
Ay,
sorry.
oo nga pala, sorry. Sorry, I'm thinking of a different PAOK.
Yeah.
Yung
Yeah.
PAOK yung nag-investigate ng Pogos. PACC, I'm sorry. Sir, are you attorney? Are you a lawyer?
No.
Okay, I
No,
was about to
no.
call you attorney Bellica, pero
Yeah.
it's not.
Thank
Okay.
you.
Anyway, sir, first things first, I'm sure nakinig po kayo, you listened to the whole part 1 and part 2 of today's confirmation of charges hearing. What do you think so far?
Nakakalungkot dahil listening to the hearing, bakit doon ginagawa? All those hearings could have been done here. In fact, more of the truth could have been taken up if it was done here. For example po, the ICC, after the revelations of the Marines, we learned that the witnesses was spoon-fed by Senator Trillanes na ginamitan pa ng corruption money. So, paano mo makakuha talaga yung side kung it was politically motivated and politically influenced? Number 2, ano ang pagkakataon ng ICC malaman kung ano talaga naging sitwasyon dito sa Pilipinas pre-2016 before President Duterte came. So, ang ganda po sana nung idea na malitis, I have nothing against being charged, a case being filed, pero bakit doon where it's so hard to fear the truth? And all the questions that were being asked and how the hearing was being conducted can all be done here. Bigyan ko kayong concrete example, ma'am. I remember bigla na yung kaso mismo, similar case, ni President Ferdinand Marcos Sr., EJK 3,200 deaths. Sabi po, ang allegations was 30,000. 35,000 survivors ng torture and 70,000 incarcerated. And these were all politically motivated, mga political dissenters. Na-solve po lahat dito. In fact, gumawa pa ang Pilipinas ng batas para mabayaran yung 11,000 victims na nirecognize na nakuha from the 10 billion pesos na na-recover. Comparing it to the case of President Duterte, 6,000 death na officially na inadmit, 160,000 na pinakulong. Bakit yung kay Marcos na resolve naman dito, nabayaran pa, yung kay Duterte nandun sa ICC? And in fact, recent history tells us na the Philippines is capable of handling high-profile cases as it did. It sent to jail 2 presidents, President Arroyo and President Estrada. It sent to jail 4 senators, Senator Bong Revilla, nakakulong na naman, Senator Estrada, and Senator Juan Ponce Enrile, house arrest, and Senator De Lima. So ang point, the Philippines justice system is slow, but it is working. So yun lang po ang aking pananaw doon, na nakakalungkot at the same time na bakit natin isinurrender ang ating soberenya bilang isang bansa. So now the Philippines is, ganito na ba tayo ngayon na we are now ruled and governed by another set of law, even by a court that is not even a state by itself and we're no longer member of. Yun lang po.
Okay, there's a lot to unpack there. First of all, the thing that you were saying that former Senator Sonny Trillanes spoon-fed the witnesses and paid them with corruption money, that hasn't been proven, by the way. That's just an allegation. I just want to make that clear. Pangalawa, 6,000 deaths is still 6,000 deaths, sir. That is still a lot. Kahit na i-compare mo pa po sa ibang periods of time.
Kahit isa nga lang, ma'am.
Yes, exactly.
Ito na yun.
Yes, correct.
At ang sinasabi ko lang po, ang kaso ni Ferdinand Marcos Sr. is similar to the case of President Duterte that was tried here.
Okay, but...
Ayun lang po ang point ko doon. Ibig sabihin, sana dito na lang. Ngayon, kay Sunny Trillanes, ang point ko lang po doon, there are allegations that Sunny Trillanes received 100 million pesos and spoon-fed the witnesses. Yun nga po so how will the ICC treat that now?
So those
Yun nga po, if it was here,
yeah,
then mas malinaw. Pwede mong patawag si Sunny, pwede mong patawag yung mga yung mga yun lang po ang point ko, kaya sana dito ginawa.
Right, but those are mere allegations which former Senator Trillanes has denied. Now, about your question...
You're defending kasi Trillanes.
No, I'm just saying, I'm just saying, iba yung allegations of facts.
Sana si Trillanes ang nagsabi nun You're interviewing
No, we have interviewed him.
Para maging patas.
We have interviewed him.
Yung President Duterte, allegations din yun
Okay.
So dapat i-try dito. That's the point.
That's allegations with proof as collected by the human rights organizations. Pero wait lang. Let me move on to the next point.
No, you brought it there.
No, let me move on to the next point. Ferdinand Marcos Sr. was in power 1965 to 1986. May ICC, may International Criminal Court na back then, but the Philippines didn't ratify the Rome Statute until August 30, 2011. So that answers your question, why Ferdinand Marcos Sr. wasn't brought to the Hague, because we weren't part of the ICC
the Philippines is capable of handling high-profile cases.
Right.
The very reason na ginagamit po ng mga nagpadala sa kanya sa Hague.
But during his time...
Ma'am, I thought it was an interview. Why are you asking for the opposition?
No, I'm not asking for the opposition.
Yung mga points ko, I don't know, bakit kayo sumasagot
for them?
Yeah,
I'm not answering for them. I just want to be clear what's an allegation and what are facts. And to answer your question about the Rome Statute, we didn't ratify it until August 30, 2011. But let's bring it back to today's confirmation of charges hearing. So my question to you wasn't about the jurisdiction. It was about what you thought of Attorney Nicholas Kaufman's defense.
That's what I thought, ma'am. I thought that all the questions and all the hearing and how it was going could have been done here. Yun din ang proseso, it was here. So I have no problem with the president being charged and for investigation. Tama po yun kung yung mga nagreklamo. What I'm just saying is sana dito na lang para nasa korte natin at mas ma-fair out natin ang katotohanan dahil nandito lahat ng katotohanan Alam po ba ninyo, ma'am, maybe I don't know if you know this, but before 2016, ang sabi po, ang official reports ng PDEA po mismo 92% of all barangays in the NCR are drug affected. Number 2, that all 100% of all heinous crimes committed are drug related. Number 3, na nung pre-2016s, mga police officials, police generals, politicians, media, what else, judges, were all part of the drug syndicate. Kaya po lumawak ng ganyan. So, does the ICC know that? And nung panahon po na yon, hindi naman kaila kahit kanino, nakakatakot naman po talaga maglakad-lakad sa labas dahil sa nababalitaan natin na patayan at krimen na nangyayari that were all drug-related. That was the reason na kaya nagkaroon ng drug war na kinoy ng media or yung pagpapatupad ng mahigpit sa batas. So, now, yun lang po.
No, it's okay. I was letting you continue. Baka sabihin mo, I'm not interviewing you. But specifically about the strategy of Attorney Kaufman today, what did you think? Again, it's not about the jurisdiction, but he made some, today, he mostly focused on discrediting what they call the causal nexus, yung connection, the direct link between the speeches of President Duterte to the killings on the ground. What did you think of that strategy?
I think that is the right strategy to take dahil you are finding and they're trying to find the direct link of President Duterte against the alleged state-sponsored killing. Ang point there was no state-sponsored killing. Ang mga nagpatayan po noon are those um, gangsters and police officials that were all involved in drugs. They started to clean up their mess. The president, even kahit po yung official na drug program ng Pilipinas during that time was called Oplan Tokhang. Tokhang, yung kausapin, yung katukin, kausapin. Oplan double barrel. It was actually the media who coined the drug war. Na yun po ang pinag-uusapan sa ICC ngayon. But then, yun po. So, si Kaufman was explaining it that way, that the explanations were, hyperbole. Hindi siya hyperbole, hindi siya, ito patayin mo, na yun ang sinasabi naman po ng kalaban. So I think he explained it quite well. I hope he could have explained it better. But then, yeah, he did explain it correctly.
But bakit naman he could have explained it better? What part specifically did you want him to explain better?
Sa akin lang po, the way he was explaining it, parang he did not give the complete story kasi hindi naman nila ramdam yung how it was here. When, gaya po ako I know the streets. And when I hear those words, I understand those words quite clearly. Na, ingat kayo dahil you'll get in trouble. So, it stopped a lot of people who were already in drugs, who were already pushing, who were already, kahit pa small time pasali-sali, yung fear na they might get in trouble, they might get picked up, really stop a lot of people from getting to drugs. And that kept the streets safe.
Oh, they might get picked up or they might get killed as well, di ba? There was a real fear back then.
Po yun.
Oh.
Yes, but the gangsters, the drug lords, and the drug addicts, and the policemen who were involved knew exactly what it meant. And that stopped them. That did the job. Pero yung para i-convict ka na ikaw ang nagpapatay, iba po kasi yung elements nun . It has to really be direct. But the order was not that. He was talking about, example, yung pag naglaban. So it was really self-defense.
Okay.
Pero I don't think the Europeans would understand it that way. Yun lang. I think if it was a Filipino judge, may intindihan yun, like, hindi naman lahat ng tao rito, mas maraming mahirap, hindi naman lahat ng tao mayaman.
The judges are, well, only one of them is European, by the way, the presiding judge. Judge Julia Antonella Motok. But anyways, we'll leave that there. We've run out of time. But thank you so much for joining us today and giving your perspective. Former PACC, hindi na PAOK, PACC Chairman, Greco Bellica. Salamat, sir.
God bless.
We'll give you more updates when we return. We just need to take a very quick break. This is, of course, Duterte's ICC confirmation of charges, a special coverage. Please stay with us. Welcome back. The defense continues to lay out its arguments on the charges being faced by former President Rodrigo Duterte in relation to the charge of crimes against humanity. At this point, let's get a reaction from some legislators. We're speaking to Kabataan Party List Representative Renee Ko. Good evening. Good evening, Congresswoman.
Good evening. Maraming salamat po sa pag-imbita sa programa ninyo.
Thanks for joining us so late. But I'm sure you were also watching the hearing all throughout this evening. First things first, what did you think?
Well, the arguments of the defense are expected because, again, ample opportunity has been given to the counsel of President Duterte to lay down kung anong reason bakit hindi totoo yung charges, which is crimes against humanity, for his role as indirect co-perpetrator for the war on drugs, which killed 30,000 people, no, more or less, here in the Philippines. As we notice, no, full of cherry picking arguments, full of defense saying that this is all tough rhetoric, no, not to be taken literally, but it doesn't hold water doon sa strong arguments ng prosecution, not only basing it on speeches, but holding internal documents, saying that there are targets and there are evidence to say that they are neutralized by the Davao Death Squad and later to be implemented on a national level, which resulted in the arbitrary killings of many victims of drug use, of drug war, that has spread fear among the Filipinos and their families. So for us, despite the fact that the counsel Kaufman continues to grandstand in this forum, I think this is a sigh of relief for victims who are, looking at the defense and not seeing any strong evidence. Sana po makahinga rin kahit papaano yung mga biktima sa kanilang strong case yesterday and moving forward.
Congresswoman, let me just set the record straight. The 30,000 that you cited is, of course, the figure from human rights organizations. The official figure from the administration, from the government, was closer to 6,000. And in fact, today there was another figure that was thrown around by Attorney Kaufman, 5,281 deaths in operation. His point being, and I'm not sure if you remember, he showed a slide at this point, his point being the number of deaths in operation was only about 3% of the total police operations conducted, anti-drug police operations conducted in the period from July 2016 to Feb 2019. What did you make of that?
We give strong credence to the findings of human rights organizations that provide that number, yung 30,000. Kaufman and his counsel and his team can put forward that number, and they should be able to explain how the internal processes led to that tally. But when it comes to human rights organizations who document the killings left and right that happened since President Duterte entered his term, a lot of these police operations either happened using a different category or declared deaths that resulted in a different manner or used different weapons, etc. That can lead still to the number of 30,000. So I think because na-veto ng matagal ng human rights organizations, and ito yung naramdaman ng mamamayan na especially when kinonsider natin yung pambansa or the national scale of these operations. That's why ito ngayon yung kailangang sagutin, no, ng defense ng maayos, no, how they're able to arrive at that tally.
One thing that I thought came across quite powerful in terms of the defense's arguments is that when when Nicholas Kaufman, Attorney Nicholas Kaufman, said that there's no smoking gun, that there's not one demonstrable incident that shows direct order as far as the killings of these 49 incidents that were presented to the pretrial chamber. He also, I guess, was casting doubt on the causal link between Duterte's speeches as well as the killings on the ground. Of course, I know you're not a lawyer, but what did you make of that? You didn't think that that was also a strong argument?
Well, I am a lawyer, but I have
I'm so sorry.
practice.
I totally missed that. I'm so sorry.
It's okay. But I have no practice when it comes to international law.
Pero as an
and I'm also-
argument, does it hold water?
I think that misappreciates the charge of President Rodrigo Duterte, which is that he is an indirect co-perpetrator. No, so even though hindi niya hawak yung baril, or there's literally no memorandum that goes, this person kill him, we have sufficient evidence on hand to portray the causal links that establishes that when there are speeches or even orders made by President Duterte, there are events and consequences that would occur, and internal records would shift and change. So because this causal link is established, or at least the prosecution provides that narrative or that establishment, I think you can't say that definitively strong yung argument that there is no smoking gun. And in many cases, in different jurisdictions, when we appreciate yung criminal liability of one person, syempre, in criminal cases here in the Philippines, may bigkabigatan talaga ng pagtingin ng ebidensya. It's not just circumstantial evidence. But here, that causal link is not just circumstantial evidence. There are different records, etc., that tend to prove that it exists. So for now, we will of course wait for the appreciation of the International Criminal Court. Paano niya tatimbangin yung dalawang yun? But for me, matibay-tibay yung causal link na na-establish ng prosecution.
The other point of contention was the word neutralization, or to neutralize. See, Attorney Kaufman made the argument that neutralization does not mean to kill. It means, it means self-defense if their own lives, if the police officers' own lives are in danger. He even cited a legal document that says it may include capture, surrender, or other acts to subdue the suspect, but it does not outright mean to kill. And related to that, the fact that na-interpret ng iba yung neutralize as meaning to kill should not be on former President Duterte. What do you think of that argument?
Yes, there are different cases that has interpreted neutralize differently. I agree with different assistants to the counsel for the prosecution that a Supreme Court case defining neutralize as is pending with the Supreme Court actually would have helped the arguments of the prosecution greatly. But if you look at the documents, there are there's evidence to say that neutralize is meant literally kapag na-dispose na yung tao, or if they're killed. One such instance is between the two government officials that was in the PRRD list. One was arrested prior to the death. And that arrest and also their subsequent detention did not change that tag to neutralized na siya. No? Nagbago lang yung kanyang pagkatag when that government official died, when he was killed. So that argument was put forward with the prosecution din kahapon. And even though may ganyang argument, and I think in the opening or in the statements of the defense, ginamit din niya against the or ginamit niya for the client, which is PRRD, na neutralized quote unquote daw ni President Marcos Jr. si former President Rodrigo Duterte. In the evidence submitted, and in how police operations appreciated that word and used it in internal records, it is meant to dispose of that person or to kill. So, despite yung ganong argument na may difference in treatment, kailangan pa rin tumbahin yung nakalagay and yung change doon sa records that only happened noong May namatay na.
The issue, I think, is also that there's no document anywhere that says, if I say neutralize, it means to kill.
Yes.
I think that's the point that he was trying to make, Kaufman. But the other thing about it is, I don't know if you caught that tail end of Attorney Kaufman's submission on the merits of the case presentation. He brought in President Bongbong Marcos. He said basically that the killings had continued under his term, that if the prosecutors at the ICC recreated their bar charts in the 2 years after Duterte stepped down, meaning Marcos period na, they would realize that the killings had remained high, and in fact he said na they might run out of space on their computers because the bars would be so high. He also said, how come with these killings in the last 2 or 3 years, allegedly, how come no one has taken that case to the ICC? How come none of the victims are crying accountability? Could I have your reaction to that, please?
Well, first of all, I think it's deplorable that that argument is made in the first place, because it's also the observation of human rights organizations here. But that doesn't mean that President Rodrigo Duterte should not face his culpability over how he designed the war on drugs, how bodies piled on top, one on top of the other during the start of his term. For example, sa amin sa Makabayan, with the Makabayan Bloc and even human rights organizations that we'd worked with, we can affirm that drug killings did not stop when President Marcos Jr. Started his office. No, it continued. And in fact, the killings of activists, killings of human rights organizations, environmental workers, environmental defenders, etc., they all continued. And that is our continuing critique with the administration of President Marcos Jr. But it doesn't mean that the critique of the killings, and we still stand by the great amount and the worst human rights record of President Rodrigo Duterte, should lessen or be judged differently because yung ating panawagan at laban para sa pananagutan kay President Marcos Jr. is going is not as different, is going differently, especially since under President Duterte's term, umalis din siya ng ICC. So, mahirap na ang recourse ay sa ICC when up until now, we have not rejoined, and President Marcos Jr. has made no efforts to rejoin. Although sa Makabayan Bloc, we have passed, or we have filed a resolution last week,
Yeah,
no?
we covered that.
Saying that
House Resolution
kailangan mag-rejoin
809.
tayo sa international or sa Rome Statute. But
House,
nonetheless,
House Resolution 809 urging the government to take steps to return to the Rome Statute and rejoin ICC. You say that it represents a vital mechanism to ensure justice. But what do you say? The argument on the other side is that our local courts are capable of prosecuting these cases, are capable of handling high-profile, complicated cases. I was just speaking to Greco Belka, the former PACC chairman, and he said as much our local justice system is more than capable of handling these cases. Pwede naman i-prosecute, but dito dapat the local court should be the one to handle it because he's a Filipino. What do you have to say to that?
I think we have years, no, of evidence. We have years of practice and reality to show that that is not the case. No, our justice system is incredibly broken because these families have actually been clamoring, no, and filing cases, administrative and judicial, left and right, since nawalan sila ng kanilang mga mahal sa buhay. There are many reasons why it doesn't prosper. Either it gets dismissed at the administrative level, or matatransfer yung police officer in question to a different jurisdiction, making it more difficult to pursue, no, continuously yung pananagutan ng specific police officer na yon. They are bribed into silence, no? Our courts would take too long para mag-process ng criminal liability, etc. This is the talking point then of many of our victims who felt that they had no recourse other than to go to the International Criminal Court. And hindi naman basta-basta rin yung pagpunta nila doon, but rather they are pinpointing a specific figure in government who is designing, no, and in charge of the entire operation, which is President Rodrigo Duterte. Because despite the fact that yun nga, yung mga pumatay sa kanila, yung mga police officers, different circumstances, these officers have been protected, no, provided political immunity with the different statements, or even the bureaucracy that our victims have to navigate para lang makamit yung hustisya. So, I disagree with the argument saying that kaya namang makamit yung hustisya through the local courts. It has been years since the victims started trying that, and they've been continuously failed, no, by our justice system, which is why, no, and at the end of the day, the Rome Statute exists because it is a testament to the different failures of judicial systems across the world that have failed to prosecute yung crimes against humanity and different types of crimes against peoples. So that's why, no, when we are actually for justice, for accountability, we still echo the call na kailangan nating mag-rejoin, no, and we have to re-sign with the Rome Statute. We have to join the International Criminal Court and be compliant as well with the different customary international laws on justice, as we should be.
I see. I get your point, Congresswoman. There are some concerns, though, that if we do rejoin the ICC, if we do ratify the Rome Statute again, that instead of it becoming a court of last resort, that we, outsource all our high-profile cases to them. Anyone can make the argument that they don't trust the justice system here, that it's incapable of prosecuting, those who committed wrongdoing. So it might set a precedent, is what some people are saying. Is there any concern about that at all sa Makabayan Bloc?
If you actually look through the Rome Statute, there are safeguards so that the scenario being described does not happen. So there ought to be, no, processes that have been started at the local jurisdictions. There ought to be showing that hindi yun nagiging sufficient, no, and only kapag nagkaroon ng ganito and you you portray that in the case, aakyat, no? Or not aakyat, a recourse, no? A last recourse can be made to the International Criminal Court. And the exact reason why prior to the through the reading of the charges, no, that we're doing right now, merong preliminary hearings on the jurisdiction of the International Criminal Court. Kailangang depensahan ng nagme-make ng case to the International Criminal Court na tama yung kanilang recourse doon. No? So, rest assured actually na hindi basta-basta pwedeng umakyat lang at the International Criminal Court. No? Kailangang may level of exhaustion pa rin na gagawin sa domestic judicial system na present sa inyong mga sa state nyo, and if available, no, meron ding mga regional courses, no, for example, at the level of the European Union. And if that doesn't work, and if that fails, you can go to the ICC. So may ganong safeguards that the prosecution actually established in their case. Kaya tayo nag-proceed ngayon here. It's just unfortunate that up until now, may ganun pa ring argument, no? When there have been multiple findings and legal experts that have established that yes, the ICC has jurisdiction not only because yung the crimes that President Duterte is being charged of rather, ay within the period na member pa rin tayo, but rather na meet nila yung requirements necessary for a case na ilapag sa ICC, which is that they have exhausted yung recourse at the judicial system domestically and wala silang nakamit.
So may guardrails. You have to prove that you have exhausted your remedies on the ground first. Congresswoman, how much support do you think you'll have for this bill? House Resolution 8509, did I say? 809, sorry. 809,
yeah.
Urging the government to return to the International Criminal Court. How much support do you think you'll have in Congress with this?
I think we'll garner some support. Well, in the first place, we were a member, no? And incumbent President Marcos Jr. was a member of the Senate that ratified the Philippines, no, signing on to the Rome Statute, no, and therefore putting us under the jurisdiction of the International Criminal Court. In fact, he voted in favor of the ratification.
When he was a senator.
Yes, when he was a senator back in 2013. So the same legislators that signed on this are also, some are still in office. But at the end of the day, the one decisive in this discussion is the president himself. We actually had a discussion with this during a privileged speech of Representative Laila de Lima last week or this week about how the ICC or the proceedings at the ICC will start this week. No, I asked, no, ano po ba yung unang step na kailangan gawin? At this point, no, despite the fact that we filed a House resolution, the House of Representatives actually has no role, no, in the resigning of the Rome Statute or in the ratification of the President signing on the Philippines into the Rome Statute. What we can do best is just urging, no, the president to do so, because at the end of the day, ang decisive po dito ay ang presidente. No?
Exactly.
He can consult with the DFA, and it's a step, no, that he will most likely take, no, because they're the part of the executive. Pero ang decisive, ang nasa constitutional power to sign onto it, to sign a treaty, no, is the president. So ang may bara dito, as we see now, is the president. So we continue to challenge him and also concentrate public opinion na if indeed, no, President Marcos Jr. is an advocate for justice, he ought to, at the most immediate time, no, sign the Rome Statute again so that we can be part of the ICC.
I know in one of my first questions to you, you basically said, yes, there were killings under this administration, But that doesn't negate the fact that there were such killings as well under the Duterte administration, which is what he's being litigated for at this point. But if the killings have continued, should they be investigated as well?
Yes. In fact, no, to whatever authority my representation can provide, no, I'd like to be one of the advocates, no, para to bring into justice lahat ng mga naging biktima ng pagpapaslang ng Administrasyong President Marcos Jr. Because, well, the reality is, no, we're not a member of the ICC. So whatever inabilities of our domestic courts or local juridical systems fail to do so, wala tayong recourse right now until we get to be a member. And in fact, I think that's one of the reasons why President Marcos Jr. continues to refuse the rejoining of the Philippines as one of the member states that signed on to the Rome Statute. Kasi alam niya na once he does, no, and the Senate ratifies it, there will be groups that will file cases at the ICC. Of course, kailangan i-clear nga yung mga guardrails or safeguards as provided in the Rome Statute. But given the left and right, no, na denials of courts, for example, in providing protections towards activists that are fighting different causes, and also different non-governmental organizations or grassroots organizations being slapped with terrorist financing charges that, you know, not only them but international organizations labeled to be arbitrary. There is the use of law to harass no advocates. So I foresee that that's the reason na hindi nagjo-join tayo muli sa ICC. So nonetheless, we will continue to push no our rejoining of the ICC, and kung ano man no the accountability at pananagutan dapat ng administrasyong ito sa inhustisya sa mga mamayang Pilipino.
I hope that lays to rest the arguments that this is all just a political, demagoguery, as what Attorney Kaufman said, and political revenge on Duterte. Just to be very clear, what you said was that you are willing to, you want to push for the investigation of the killings that have continued under the Marcos Jr. administration. Congresswoman, one last question for you that's not related to ICC but kind of is related. Since we're talking about House bills, kamusta naman po yung impeachment bill? And I'm sure there's talks in Congress at the moment. Many people tell us that there's not much more appetite for an impeachment. But I recall that you were one of the only two lawmakers who interpolated Vice President Sara Duterte on her, if I recall correctly, it was the 2025 or 2026 budget. But in any case,
2026 proposal.
2026 yes. Proposal, budget proposal. Where are you on this, and what do you think might happen to that impeachment complaint?
I first join your hope that this lays to rest, that this is specifically politically motivated, because the victims of the drug war have no motivation other than justice, no, makamit yung hustisya sa pagpapaslang sa kanilang mga kamag-anak. And similarly, yung mga pinaslang din ng mga kamag-anak in the President Marcos Jr. administration want nothing but that same justice. No? So we're pushing for it, we're fighting for it. And also, ang track record ng Makabayan Bloc ay lahat ng sangkot dapat managot mula at hanggang sa tuktok. That's why we filed impeachment cases against both President Marcos Jr. and VP Sara Duterte, because they have had records and evidence against them to say that they are not only complicit but are drivers of corruption, of taking public funds for their own personal benefit. So unfortunately, the complaint against President Marcos Jr. has been dismissed for insufficiency of substance here at the House of Representatives, which we continue to criticize because sa amin, no, sufficient in substance siya kung babasahin lang natin yung patakaran at yung pamantayan na nakalagay sa House rules. No? The House had to create a motion out of nowhere to justify na kailangan na mamamatay ito at the sufficiency of substance level. Here at the VP Sara Duterte impeachment complaint, maraming ang mga usap-usapin siya because sinabayan nito ng announcement ni VP Sara Duterte ng kanyang pagtakbo, no, as president in 2028, and then there are different political actors as well signifying, no, a change in opinion compared to how they voted back in the impeachment proceedings in 2025, no, against VP Sara Duterte. But for us, no, hindi naman po nagbabago yung merits. In fact, nadagdagan pa nga yung merits to say that VP Sara Duterte betrayed public trust, no, by misusing confidential intelligence funds of her two offices, OVP and the Department of Education, with her not only attitude but her holding of the responsibility of public office, asking her staff, no, to not comply with legal orders and summons in relation to questionings of the budget and how it was used, no, etc. So sa atin, tumiba yung arguments. We continue to push that legislators vote in favor of and in line with principles, no, with a principled stand, no, and not whatever political interest na kailangang mag-play into come 2028. Of course, ongoing battle yan, and that's why we're preparing for the proceedings that will start, no, next week. No, next week, the House Committee on Justice will be convening to discuss the form and substance of the impeachment complaints laban kay VP Sara Duterte. So we're preparing and we will be, you know, opening or putting forward our best foot forward in relation to this.
How significant is it that NUP issued a statement saying that their members will likely not vote for the impeachment? And I believe NUP is the largest party within the lower house.
Well, right now, no, despite that last year may 2/3 na nakamit na signatures yung fourth impeachment complaint to VP Sara Duterte, I think it might be difficult to reach that same number, no. But still, the requirement by the Constitution and the rules is still 1/3, no. I think for the part of the majority na yung nagbibilang talaga, may confidence sila na ma-meet yung number na yon. That could have been shaken by the NUP announcement, pero sa amin, hindi pa naman sarado ang lahat. Ang amin, kailangan bumoto, kailangan umakto ayon sa lohika, no? At ayon sa anong nararapat sa bayan. And we're not only convinced, no, but we are confident with the strong arguments of the impeachment complaints showing that VP Sara Duterte held her office in a way that is incompatible, no, to the principles of transparency and accountability as expected of her office. Lalo na ang nakalagay dyan, no, dapat kung may confidential or intelligence funds, gagamitin mo for confidential intelligence purposes, di naman nagawa yun, dapat i-account mo ng maayos, di rin naman nagawa yun, etc. Kung aayon lang tayo sa paano dapat no umakto ang public officials, I think it should be clear that VP Sara Duterte has her impeachment complaint, no, has merit and should be transmitted to the Senate so that it can go to trial.
Okay, we'll be covering that, of course, but for now, we'll leave this conversation. Thank you so much for talking to me again. That was Kabataan Party List Representative Renee Cole. Salamat, Congresswoman.
Maraming salamat po.
Moving on now, the Photojournalists Center of the Philippines says they condemn any narrative suggesting that their drug war photos were fabricated. That's after attorney Nicholas Kaufman pointed out to before the ICC pretrial chamber that some pieces of photo evidence in the drug war are quote-unquote crafted. With this, let's get out to a voice on this issue. We have Manila-based freelance multimedia journalist Basilio Eli Sepe. Welcome to the show, Eli. Nakamute ka, Eli.
Right. Good evening, everyone. Good evening po. Thanks for having me.
Good evening, sir. First, can you, for those who maybe don't know the context to this issue and why the PCP had to issue a statement to set the record straight, baka you can, baka pwede mo ikwento sa amin, sir, kung ano nangyari.
First is gusto lang din namin, no, that why we released a statement. Gusto lang din namin na patunayan na hindi crafted or hindi staged yung mga nilalabas na photos ng mga photojournalists, especially during those times, 'di ba? At pinapakita lang din namin kung ano yung totoo, what's happening on the ground. At isa yan sa mga, syempre, sa larangan ng trabaho namin, yung mag-document ng reality.
Eli, kwento mo sa amin, gaano ka-strict yung mga news agencies pagdating sa mga manipulated photo? For example, yung nagagamit, the one that was shown at the ICC was used by AFP. Meron din yung kay Rafi. Halos maraming photographers na kumuha nung yung so-called La Pieta photo. Pero yung ginamit is yung AFP, tsaka meron din yung kay yung ginamit ng Inquirer. But how strict? Talk us through that process. Gaano sila ka-strict when it comes to adjusting or manipulating the photos?
Well, we've been hearing a lot of yung mga remarks na they're fake or they were staged, especially during the height of the former president's anti-drug campaign. So it was not really surprising actually that Mr. Kaufman made that kind of statement, particularly given his role as a legal counsel defending his client. Pero as for me, I stand firmly, by my work and by our work as journalists, not just with the photojournalists, na the images we documented were real and they were not staged and they reflect of what was happening on the ground. And in many cases, what was happening behind the violence, during the drug war, and which also has deeply affected, yung mga families and individuals sa mga marginalized communities. So journalists who covered that event did not create that reality. We documented it. So it was our responsibility to present facts and visual evidence so the public could understand the truth of what was really happening.
And then these photos, pagka-submit nyo sa editor, sa news agencies nyo, sa bureaus nyo, hindi na pwede galawin, correct? Or
it depends, if you're a freelance, you can there's a lot of photojournalists in the Philippines, and we have freelancers, and there are those who work for local and international agencies, and those who have a regular job or those who work regularly for a certain agency, they must submit pictures for their agency and for them to disseminate yung nakuhanan nilang picture. The same goes actually with freelancers. They have different clients, they have several clients, and they produce pictures for those organizations. And they were required also to document what was happening.
Take me back to the Duterte administration and how your schedules, how your lives were like as you followed these police operations, as you documented the crimes. I heard na nakatambay na kayo sa mga police precincts, di ba? So talk us through that. Gaano kahirap nun?
Well, photojournalists, 'di ba? We have one of the uh, toughest jobs, no, out there. We have to be in the field. We have to be on the ground for us to be able to see and capture what is happening. And in my case, during that time, I began, covering the drug war when I was still in college, when I was still working also for the Varsitarian, the official student publication of UST. So that period really became one of the turning points also of my career. Covering the drug war pushed me out of my comfort zone, and because I was studying, working, and documenting events on the ground all at the same time. So uh, it required a lot of strength, no? Also, a lot of emotional strength, critical thinking, and this deep sense of responsibility, no, to really show the truth of what is happening. And plus, it also broadened, no, yung social awareness ko about the issues in our country, also abroad, about what's happening regarding human rights concerns. So I really felt strongly that people during that time, especially the younger generation, na they needed to understand, no, what was happening, during that time. So documentation was not just about taking photographs. It was also about, preserving the truth in real time. So those experiences shaped me as a journalist. Those experience shaped me, as a journalist right now.
How do you guys know where to go? Kamusta yung, paano nyo pinaplano yun? Paano yung schedule in a week? Do you, at one given point in time, pupunta diretso na kayo sa police precinct, tapos sinusundan nyo na lang yung mga police, or may nagtitip off, or how does it work?
Yeah. We usually go there. We usually go to the crime scenes, no, as a group. Lalo for safety also, kasi we went to different places, not just I mean around Metro Manila. So ang dami nangyayari. There were a lot of crime scenes all over the city. So yung iba nga hindi na namin nakukuhanan kasi ano lang kami, we need to stay put in some of the crime scenes. So yung iba hindi na namin napupuntahan. Pero gabi-gabi yun, no? Starting siguro after dinner, around 8 p.m., sometimes earlier. And hanggang ano na yun, madaling araw. And sometimes nung tumagal, hanggang may araw na. So it was really tiring, no? Physically and emotionally, because every night you get to see that kind of scene where
Oo nga eh. Hindi ka ba na-trauma?
families are weeping, or individuals are weeping, and you get to see blood every night. So as a young photojournalist back then, ang hirap kasi I was also doing other things besides that.
Hindi ka naman na-trauma?
May times na there were times that
It got to you?
Oo, na medyo traumatic yung scene kasi hindi na siya masyado ng gory, no, kumbaga. So in other words, it's not some scenes were not picture worthy kasi my clients won't even use it.
Masyado ng gory. Because we have guidelines in terms of what we can publish and what we can air. Eli, last na, what would you say to those people who say that, yun nga, staged naman talaga. Kanina, we tackled the manipulated, crafted accusation. Pero ngayon, some people also say na these are staged, that you colluded with the police. Kayong mga photojournalists, you all went there, they staged it, tapos yun, they let you take photos, and it was that you guys were all in on it. What would you say to that?
sa panahon ngayon, no, sa panahon ng social media, sa panahon ng artificial intelligence, marami talagang magsasabi niyan. Marami talagang kakalat na fake news. Pero in our case, yun nga, in the end, it's still our responsibility, no, to show the truth, no. That's our role, no. We are also public servants, 'di ba? We have to show what's happening in our country. We're part also of history. And that's our job. That's our role as photojournalists and journalists in general is to document kung ano yung ginagawa ng gobyerno, ng taong bayan sa mga ganitong klaseng bagay. And to also make other people, no, especially abroad, what's happening in our country, diba? It all boils down, no, to those kinds of services, no, na ginagawa namin as photojournalists.
Well, you stay safe out there, and thank you so much for talking to us tonight. Basilio Sepe, drug war photojournalist and member of the PCP. Salamat, sir.
Maraming salamat din po.
Okay, let's get back to dissecting the confirmation of charges hearing, part 1 and part 2 of the defense's submissions on the merits of the case. We've got Attorney Ruben Carranza back with us. He is an international law expert. Hi, sir. Welcome back.
Thank you.
Okay, where were we? Nakalimutan ko na. But in any case, I'm sure you also listened to part 2 of Attorney Kaufman's arguments. There are a number of them. Number one, he came back to the point that prosecutors were cherry-picking the speeches, ignoring dozens of those of Duterte, stressing the need to act within the bounds of law. And he says, in fact, that makes that's far from being evidence to this case. It's in fact testament to Duterte's respect for the rule of law and disdain for rotten police officers. So here we can see that he's trying to put some space between the rogue police officers, as well as Duterte. What did you make of that?
It's still part of the same line of argument where, on one hand, Kaufman admits that Duterte did say the things he said that the prosecution has pointed out, that he urged police to kill, not just in euphemism, not just in cautious terms, but explicitly to kill. He goes on and says that Duterte would sometimes, not always, because he himself is cherry-picking what he uses to argue that the prosecution is cherry-picking. So Kaufman says in some of these speeches of Duterte, he qualifies and says policemen should, however, only shoot when they are shot at.
Yeah.
He obviously avoids referring to instances where either the police have planted guns as evidence, and he obviously, and I understand why he will avoid referring to the fact that in one, or in at least one, but maybe more of Duterte's speeches, he actually admits that he had, as a pattern, asked policemen to plant guns. So you have those two things together. A Duterte speech admitting that he has ordered the police to plant guns, and a Duterte speech saying that the police should only fire when they're fired at. Kaufman picks the fired at speech, that portion of it, omits any reference to Duterte's speech asking police to plant guns, and then he accuses the prosecution of cherry picking. At the very least, we can say both sides are cherry picking, and that's what you do as a counsel for a defendant. But the problem here is that the prosecution has a heavier burden because it also has to supply exonerating evidence to the defense, to Kaufman, to Duterte. And the prosecution obviously did not cherry pick exonerating evidence. That's why Kaufman has access to it.
So if both sides are cherry picking, attorney, did Attorney Kaufman then just weaken the prosecution's argument? Because they don't have to prove innocence here, but they can prove that the prosecution's case is built on unsolid ground.
Well, first, let's remember that this is a pre-trial hearing. This is a confirmation of charges hearing. This is not the trial, the standard in a trial, as people who watch crime TV know, is evidence beyond reasonable doubt. That standard doesn't apply here. Here, the standard is: do the judges have substantial grounds to believe that Rodrigo Duterte committed crimes against humanity of murder as charged by the prosecution, which is higher than what was required by the judges in the pretrial chamber to issue the warrant of arrest against Duterte. The ground at that stage was, do they have reasonable basis to believe? Here it's substantial. So it's higher than issuing a warrant, lower than convicting the accused, Rodrigo Duterte here. In this case, even when Kaufman challenges the prosecution's use of Rodrigo Duterte's speeches and says there are qualifications to it, those speeches call for killing, call for murder. If you were a judge, would you say that was using those speeches, referring to them, listening to Duterte in the videos that were shown, would you think that this is substantial enough for you to say he may have really ordered killings? What about Kaufman's qualification? Then, as a judge, you will ask yourself, does that negate the fact that he was ordering killings? Does that possibly simply mean he was trying to cover up his own orders? Or does it mean he was just joking? Right? So now you have a choice. Which choice is more substantial? That's the question for the judges.
That's a delicate balancing act. Only 3% of there were only 3% deaths in total out of the total personalities arrested in anti-illegal drugs operations from 2016 to 2019. That is from Attorney Kaufman again. He showed that chart. I'll flash it right now, that bar chart and the pie chart to the right. He says, in comparison to the number of arrests and operations conducted, the number of deaths is minimal. Minimal in this case. 3%, by the way, equates to 5,600, let me just go back, 5,281 people. There's a lot of numbers being thrown around. Human rights organizations say it's closer to 30,000. The official government figure is about 6,000 or so, and now he's brought out another number, 5,281. What do you think he was trying to do here? And also, if I may just connect that to the latter part of his presentation, wherein he said the figures are just as high under President Bongbong Marcos. Why isn't anyone investigating that? And why are the victims not crying for justice there?
Let's go to the figures first and where they come from. They come from the government agencies that were operating and being used during the drug war of Rodrigo Duterte's presidency. People will recall that the named co-perpetrators in the charging document of the prosecutor, they're not yet charged, they're not yet arrested. We don't know if there are warrants against them, but there are 8 of them. And out of these 8, at least 3 or maybe even 4 actually either headed the Philippine National Police, including De La Rosa, including another person, or headed the Drug Enforcement Agency or the National Bureau of Investigation, if I'm not mistaken. In other words, some of the named co-perpetrators were heads of the same agencies who produced those pie charts, who produced that bar chart, who came up with those figures. That alone casts doubt on Kaufman claiming that this is the number of deaths, and this number of deaths is significantly smaller, fewer than the total number of people arrested. In other words, he's arguing that these deaths were incidental to arrests. The target was to arrest. I mean, the directive was to arrest, not to kill. Even if we set aside the obviously self-serving data that came from the persons that are now named as co-perpetrators of Rodrigo Duterte, 5,000 people killed in a span of how many years is not minimal.
3 years.
Sorry.
3 years per his charts. 3
Yes.
years.
So within 3 years, 5,000 people killed. The only reason we call it, and Duterte calls it a war on drugs, is because we know what wars do. Wars lead to casualties. A police encounter, whether one person is killed or one person is arrested, it's not a war. Two police encounters where two persons are killed perhaps isn't a war. But here, we already go into the legal aspect of how many people have to be killed for there to be a crime against humanity of murder. The answer is 2 or more. So even by that very technical threshold, 5,000 dead far exceeds the number of people murdered for the charge to become the crime against humanity of murder. So that's the answer to these numbers. The fact that murders continued under Ferdinand Marcos Jr. is both unsurprising and not an argument against charges of crimes against humanity of murder against Rodrigo Duterte. Maybe Nicholas Kaufman is calling for Marcos Jr. to also be charged with crimes against humanity of murder. Maybe he should prepare. Anybody can actually file a complaint. It's called a communication, not a complaint, at the ICC. And Nicholas Kaufman can even ask his own client, who right now is probably just sitting reading magazines in his jail cell, to do that. So accusing Marcos Jr. of also presiding over drug war murders does not mean that Rodrigo Duterte did not commit drug war murders. That means probably, possibly, both of them commit drug war murders.
And as you pointed out, anyone can file a communication. Attorney, we will leave that there for now because the hearings have started up again. So we'll tune in and come back out to you later on. Thank you so much.
Sure.
Let's now tune back into the third and final session of today's confirmation of charges hearing against former President Rodrigo Duterte.
The parties and participants to ensure that their submissions are worded in such a way as to avoid going into closed sessions, thus ensuring the transparency of the proceedings and to avoid the disclosure of confidential information. The Chamber would remind the parties to comply with these instructions. Furthermore, the Chamber is of the view that the information that was asked to be redacted and also from the direct broadcast today were limited to identifying information of witnesses and victims mentioned during the submissions. The defense disclosed information on several occasions that allowed for the identification of victims and witnesses. For example, positions held and nicknames, things that must not be disclosed so as to ensure the protection of witnesses and victims. The redactions had only to do with identifying information and were not as general redactions to the events within the case. This was the appropriate recourse to implement the Chamber's duty to protect the safety and well-being, including psychological well-being, the dignity and privacy of victims and witnesses in accordance with Article 68 of the Rome Statute, without having to hold the hearing in private or closed session. Thus, the Chamber has decided to maintain the redactions that were applied earlier and reminds the defense not to disclose information that may not be necessary and information that could identify witnesses and victims in accordance with Article 8 of the Code of Conduct of Counsel. I thank you very much. And Mr. Kaufman, you may now proceed and continue your submissions on the merits. You have until 3 p.m. Thank you very much.
Thank you, Madam President. As you can see, we have a number of yellow post-its on our table here. These are the document identification numbers of all the matters that I'll be talking about. But since we only have until 3 and until 1 hour tomorrow morning, I can provide the ID number if necessary, but I will move on, and we promise to give the Chamber at the conclusion of the hearing the full ID numbers of everything that I've talked about. And if the prosecution obviously wants something as well, he can...
Afternoon, Madam President. I would just ask my friend if he can read out the tab numbers, because every item per the Chamber's instruction has a tab number. So even if my friend doesn't read out the entire ERN of the page he's citing, the lines, if he gives us a tab number, at least we can check his homework in real time.
Merci beaucoup.
Thank you very much. Counsel, are you in agreement with this position taken by the prosecution? Well, the representative of the OTP. Mr. Kaufman, yes, ma'am. Judge Motik, please proceed.
Come to ask myself another question concerning the nature of a common plan theory which applies equally to its subjective requirements. Has the prosecution shown substantial grounds to believe that Rodrigo Duterte's implementation of its fantasy criminal scheme was of such a nature that the murders detailed in its 49 charged incidents would have ensued as a virtual certainty in the ordinary course of events, and that he foresaw that they would occur as a virtual certainty in the normal course of events? Let us take a moment so that I can assure you that these wonderful words, virtual certainty, actually do exist in the court's case precedent and are not a fiction of my own. If you will, please display the first of 2 citations from the Abdul Rahman, otherwise known as the Ali Kushaib trial judgment from 2025. First of all, paragraph 795. While the common plan between individuals need not be specifically directed at the commission of a crime, it must nevertheless involve a critical element of criminality, meaning that in the context of the specificities of the case, it was virtually certain that the implementation of the common plan would lead to the commission of crimes. We can have a look at paragraph 706, and it talks about the general knowledge requirements, which I am sure Your Honours are very familiar with. So, with respect to the question whether the common plan entailed the occurrence of murders as a virtual certainty, the answer is an emphatic and resounding no. First of all, let us recall what the prosecution defines as the former president's list of high-value targets, what the media calls the kill list, and what one of Mr. Edward Jeremy's quoted witnesses referred to as the dead list. The number of individuals on this so-called kill list, the very list on which the prosecution relies to show the knowledge that death would ensue, is 4,817. Those who are actually neutralized dwarfs in comparison and stands at 248. So, assuming that neutralized actually means killed, which it does not, then there is no virtual certainty attributable to Rodrigo Duterte that death would ensue from this kill list. Rather, a 5% chance. Let us have a look at a bar chart for exactly the same figures used by the prosecution as distributed geographically. I now turn to the issue of control, as it did or did not manifest itself in the crime base. In other words, can it safely be argued that substantial grounds exist to believe that Mr. Duterte's supposed diktat filtered its way down from his mouth and via his co-perpetrators to those who were supposedly going about committing these murders? How has the prosecution shown the concept of automatic compliance, or even virtually automatic compliance, so essential to its pyramidal structure? Well, by and large, and judging from Ms. Robin Croft's submissions, it would appear that the concept of automatic compliance is substantiated by reference to subjective comments made by perpetrators who talk about their will being controlled. For example, transcript, page 37, line 7 onwards. I felt like that I didn't have any choice but to follow their orders. It wasn't possible not to obey his commands. Another example, transcript, page 38, line 17. Co-perpetrators controlled the will of the physical perpetrators. End quote. According to the prosecution, members of the Davao Death Squad had to seek clearance from Mr. Duterte to conduct killings in Davao City. For this wild assertion, the prosecution relies once again on the evidence of criminals it has recruited, all of whom are inherently unreliable because of their being self-confessed vicious murderers, testifying in return for virtual immunity from proceedings at the ICC. We shall analyze the testimonies emanating from these individuals in detail later in my submissions. Now, I can see Mr. Nichols scribbling away there, but I shall be referring to what are called statements of limited use. As for the other modes of liability charged, ordering under Article 25(3)(b and Article 25(3)(c), aiding and abetting, as I have said, no smoking gun, no evidence of a direct order, solicitation, or inducement with respect to any one of the 49 incidents. no documentary record exists of a presidential order. So how could these orders have been transmitted for the purposes of Article 25(3)(b? Well, unless Mr. Nichols envisages mental telepathy, I think that we can discount ordering. The prosecution has failed to elaborate in its oral submissions what it means truly by soliciting. If it means the ambiguous public speeches, then it is difficult to reconcile the frequent exhortations to self-defense with soliciting, unless, of course, you accept that Mr. Duterte super craftily inserted these exonerating comments into his speeches in order to craft himself a defense when the day of reckoning would come. As the prosecution asserts, speaking with a forked tongue, sometimes speaking his mind, sometimes saying what he wants you, your honours, to hear. Furthermore, generalized statements months before specific incidents do not establish causation or instruction. For aiding and abetting, there is no reliable evidence that Mr. Duterte provided practical assistance, encouragement, or moral support that substantially affected the commission of a crime, with knowledge of the perpetrator's intent. And finally, on modes of perpetration, modes of liability, I would beg you not to take heed of Ms. Paulina Masseter's assertion that Rodrigo Duterte failed to prevent or punish. The prosecution has not charged command responsibility under Article 28. And the reasons for that are clear. It is the same reason why it cannot prove ordering. There is no ascertainable chain of command descending from Duterte at the top via the co-perpetrators, so-called co-perpetrators, all the way down to the crime base. As I said, it all breaks down at the level of the co-perpetrators. And I would ask you very respectfully not to exercise your discretion to requalify pursuant to Regulation 55 of the regulations of the court. But if you do, and you shouldn't, I respectfully submit, you should order the prosecution to resubmit its document containing the charges and its pre-confirmation brief as amended, and to release Mr. Duterte in the interim. Now, I have finished that section of my submission, and I will now turn to the witnesses themselves, and I will be very careful not to mention anything that I'm not meant to. And I will discuss, first of all, the general reliability. A genuine criminal investigation is meant to be directed at establishing the truth. It is meant to elicit facts in an impartial manner and not to present witnesses with a preconceived idea and to seek confirmation thereof, whether it be by way of leading questions or anything else. By this, I mean that the golden thread linking practically every one of the interviews of the prosecution's so-called insider witnesses, who are, for the most part, ruthless criminals, is the a priori targeting of Rodrigo Duterte. In my submission, no real attempt was made to perform this duty of examining exonerating circumstances, or even to establish the existence of other actors who might be responsible for the high incidence of deaths in the context of the war on drugs. Most prosecutors will collate the evidence and thereafter analyse it and decide whether to prosecute with a view to obtaining a reasonable prospect of conviction, which is indeed the standard supposedly applied since Mr. Karim Khan assumed the role of chief prosecutor. A prosecutor is not meant to choose his target in advance and then find the evidence to support a preconceived desire. Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts and common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session. Neither the Rome Statute nor its accompanying texts regulate the way statements of limited use are employed. I would like the pre-trial chamber to consider the way academics and the prosecution itself has qualified the implementation of limited use statements in the past. And I quote from paragraph 49, which is open source, of a chapter on the Office of the Prosecutor in the 2022 edition of the Max Planck Encyclopedia of International Law, written by no less than Judge Betty Hohler of this court. And I quote, "One of the agreements the OTP may enter into during the investigation is an agreement with a person suspected of committing crimes within the jurisdiction of the court, is to provide a statement of limited use. The idea is that the person provides the Office of the Prosecutor with an oral or written statement for the purpose of pursuing leads or developing additional information or evidence on the condition that the statement will not be used against the interviewed person except as stipulated in the agreement. The purpose of such agreements is to ensure cooperation of so-called insider witnesses whom the OTP does not intend to prosecute, but are expected to provide key information or evidence against other, usually more senior suspects." Judge Hohler was effectively relying on footnote 20 to the prosecution's own filing, number 1118, in the Bemba Article 70 case, which states the same thing. Both sources stress that limited use statements should be used as a rule to pursue leads or to develop information, but not apparently, outright at any rate, to serve as the key and main testimony against a suspect. In my opinion, there is a good reason for this, and it is contained in the wording of Article 54, 3d of the Rome Statute, which is cited as the statutory basis for limited use statements. The prosecutor is entitled to enter into such agreements granting limited use on condition that the agreement would not be inconsistent with the statute. And I stress those words, not inconsistent with the statute. Using the evidence of self-confessed murderers to obtain leads or develop evidence from other sources, I would suggest, is consistent with the statute, as mentioned by Judge Betty Hohler. To give a get-out-of-jail card, however, to a whole bunch of murderers in order to fix liability to another, albeit pre-selected individual, also selected of murder, is, in my opinion, totally and wholly inconsistent with the object and purpose of the Rome Statute, which, according to its preamble, oft cited by the victims and the prosecution, is dedicated to the eradication of impunity. In my opinion, granting immunity to a murder suspect for core international crimes would be seen as undermining the object and purpose of the Rome Statute. Accordingly, I would ask the Chamber to find the statements of those witnesses afforded such limited use and to be of negligible evidentiary weight. Another issue pertaining to the general credibility of the prosecution's witnesses is the way in which they were recruited. In my opening remarks a couple of days ago, I talked about the general fairness of pursuing charges brought by a prosecutor who was formerly a representative for more than 100 victims of Mr. Duterte's alleged crimes. I also talked about a recorded telephone conversation in which one of the participants bragged about acting as President Marcos Jr.'s silent partner for channeling witnesses to the ICC. Apparently, I raised the presidential spokesperson's hackles considerably. So let me quote a bit more so that I can assure her that my cognitive faculties, which she doubted, are in fact intact. And this is what this covertly recorded individual, who I'm forbidden from naming, said. They cooperate through me, since I don't hold a position, redacted. But we are able to do it. So what? What happened here is an ICC investigator will give me a list of witnesses, documents they need to bolster the case against Duterte. Then I provide it. I give it to the different agencies so it can be approved. There are witnesses who need a pardon. I get the authority from the president, and they are granted a pardon. Basically, like that, it becomes a priority mission of the government. I don't think I've disclosed here, Madam President, any working methodology of the Office of the Prosecutor. So now I turn to the incidents themselves, the 49 incidents. The prosecution invites you to view these incidents as the manifestation of a much larger pattern. To quote the prosecution's very words in filing number 330 at paragraph 5, the 49 incidents are a non-exhaustive list of examples of the conduct underlying the charges. Indeed, the prosecution speaks of thousands of victims in toto, data sets, and patterns of violence. Now, the defense does not deny that much drug-related violence did occur. It was occurring before Mr. Duterte assumed the reins of power and continued, as we have shown, by way of a sharp increase after he left office. But these grandiose visions of the prosecution are of no avail if the core criminality and incidents alleged in its document containing the charges are not made out. So the question before you is whether there are substantial grounds to believe, firstly, that each of these specific incidents were unlawful killings, namely deliberate acts of murder, and secondly, that they were knowingly committed to further the criminal objective of the so-called common plan or the state organizational policy with which it has been conflated. And finally, that they are indeed attributable to Mr. Duterte under a recognized mode of liability. Preempting a possible defense, always a good tactic for a prosecutor, unsure of the strength of his own case, there is a heavy reliance on expert analysis of data sets to argue that reported instances of self-defense were statistically improbable. Let me stress that it is the defense's view that if the contextual case depends on the scale of victims, namely thousands, as alleged by the prosecution, then establishing the evidentiary integrity of each charged incident is imperative. In other words, the defence firmly submits that the pre-trial chamber should not commit any one of the 49 incidents to trial unless it concludes that there are substantial grounds to believe that Mr. Duterte's criminal linkage and liability has been established for each one. When these 49 incidents are disaggregated and examined one by one, as the statute requires, we submit, what becomes apparent is not the cumulative strength, rather the recurrence of certain symptoms of inherent weakness in the evidence. These weaknesses fall into 6 broad categories. The first is the over-heavy reliance on the testimony of cooperating witnesses who are inherent criminals with an inherent propensity to be unreliable and whose statements, as I mentioned, are not corroborated by external evidence. The second, hearsay attribution, or in less legal parlance, incriminating statements heard from a source twice or even 3 times removed. The third weakness, which infects the evidence, is the fact that some of the victims are unidentified, making it virtually impossible for the defence to pursue its own lines of inquiry. This weakness affects at least 9 out of the 49 incidents. The fourth weakness, documentary records, such as police and forensic reports, are at variance with and are contradicted by testimony of a single prosecution witness. Fifth, the hoary old chestnut of conflicting statements emanating from 2 or more witnesses testifying to the same event, some contradicting one another, some contradicting even themselves. And finally, the 6th weakness being the repeated absence of any evidence to link the hitmen to our client, despite the prosecution's best efforts to chivvy such linkage out of them. The defence will now show how these identified weaknesses reduce below the substantial grounds threshold the evidence for these incidents. In the 3 counts, as they appear in the document containing the charges. Count 1, the alleged murders during the mayoral period. Count 2, alleged murders of HVTs, the high-value targets, during the presidential period. And count 3, barangay clearance operations also during the presidential period. So I shall start with count 1. As we know, the first cluster of incidents falling under count 1 concerns the so-called and totally fictitious Davao Death Squad period. This concerns incidents 1 through 9 of the document containing the charges. The prosecution's attribution theory here is straightforward, that Rodrigo Duterte, as mayor, authorized killings through intermediaries. But when the evidence for this count is examined, as I've already mentioned, not one witness can say that he heard the mayor give an order to kill. The attribution of criminality to Mr. Duterte arises, for the most part, out of assumption layered on top of hearsay and follows a repetitive pattern which would, as a rule, entail the same mechanism of attribution. Namely, a hitman witness for the prosecution would state that his handler said that clearance came from, and I quote, above. But what does the word above mean? It means an unnamed superior and nothing more. The mode of liability imputed to Mr. Duterte, namely indirect perpetration, requires the prosecution to establish a stable chain of command through which the common enterprise filtered. If there indeed existed a structured approval process, as the prosecution alleges, one would expect operational consistency, not variability. The incidents contained in Count 1 are also marked by internal inconsistencies which cannot be reconciled and which are indicative of the fragility of the prosecution's overall case. Incident number 1, for example, is based on the evidence of 2 witnesses who contradict each other on fundamental and materially crucial issues. Let me explain in more detail. P26, who presents himself as a participant, claims that Mr. Duterte telephoned a redacted third party to order the operation and was told that it was the mayor on the phone. Was told that the mayor was on the phone. Pure hearsay. The prosecution seeks to reinforce this through P2. Yet P2 was not present at the time. He was inactive, for reasons I can't mention, and relies entirely on what he heard from the redacted third party and another individual at a later date. P2's account is therefore pure, unadulterated hearsay. More significantly, it diverges from P26's version on fundamental points. The year of the incident, 2014 and not 2013. The number of victims, 2 rather than 3. The identity of the perpetrators. The channel through which alleged clearance was conveyed, via driver and bodyguard, to a different DDS member rather than through redacted. And if that is not enough, the method of killing, strangulation rather than stabbing, these aren't minor inconsistencies. They concern the core factual matrix. If the pre-trial chamber is unable to determine even these basic circumstances which establish opportunity, method,
we lost the feed just then, but that was Attorney Nicholas Kaufman. Now at the tail end of his presentation and this submission on the merits of the case. This is part 3 now, and we only have about 15 minutes more to go. This is the part where he lays out the so-called 6 weaknesses, not witness weaknesses, of the prosecution's case. Chief of them that stood out for me was the repeated absence of any evidence to link the hitman to Duterte. And again, there was a mention of the inherent unreliability of linking the speeches, his public speeches, to the killings on the ground. That is what Attorney Kaufman said. He says all of it, the linkages, all break down. The connections that the prosecution is trying to argue, it all breaks down at the level of the so-called perpetrators, because there is no direct link there. He says there is absolutely no documentary evidence that exists of a presidential order to kill, to kill suspects in the drug war. And he he said unless there was such a thing as mental telepathy, then there was no way that President Duterte could have ordered all of those killings, because there's no such evidence that showed that he actually directly ordered the killings of these drug war suspects. He also pointed to the fact that he alleged that the criminals' testimonies were inherently unreliable, and that they were largely testifying on the hopes that could be an exchange for immunity. That's what Attorney Kaufman said in his speech in Part 3 of this confirmation of charges hearing. He says there's no such thing as automatic compliance to what Duterte says in his public speeches. Automatic compliance, as defined by the prosecution, according to Kaufman, refers to the subjective complaints by perpetrators. The key word there being subjective, of course, subjective. He is trying to paint a picture that that was their own interpretation of his speech, that Duterte never actually said go out there and kill. And again, neutralization in this, by his definition, means only to arrest and to act in self-defense. Okay, let's tune back into the rest of this hearing.
Since the prosecution made such a big deal out of Incident 3 on Monday and screened the video of the hit job itself, if you recall, the one in a marketplace which was supposedly viewed with approval by our client, I would like to devote a few words to it. If your honours follow the transcript that accompanies this video viewing session, the prosecution fixated on the comments of Mr. Duterte telling the person operating the video not to zoom in.
The feed there again, but that was Attorney Nicholas Kaufman almost concluding. There's only about 12 minutes left to his time here in the submission on the merits of the case. I believe he was about to mention the fact that a journalist from Davao is contesting the prosecutor's use of the video that showed allegedly someone being killed by vigilantes. This journalist, his name is Jason Tesiorna, is asking for an apology from the International Criminal Court and for them to take it out of the official documents here. Ben had alleged that this video that the prosecutors had submitted in this confirmation of charges hearing was taken during a media event that was meant to showcase the 911 hotline in Davao City, and was not actually meant to show any such alleged vigilante killings. But there we go. This is the video that we're talking about. He said, this journalist, Tesiorna, said that the CCTV footage that was shown at the hearing earlier this week, which showed that then Mayor Rodrigo Duterte was seen reacting to the footage. I'm sorry, it wasn't just one suspect that was killed. There were 3 alleged thieves at the Agdao Public Market in Davao City. So what the prosecutors did was argued that the footage showed Duterte appearing to take pride in the killings and suggesting that the assailants were linked to the so-called DDS. But now, Ben Tesiorna has said that he was present when the video was recorded, and he disputes that interpretation. He said the footage was taken in 2013, again, during a media event to observe the newly established Central 911 Operations Center in Davao City, and that the former president was merely demonstrating the city's emergency response and surveillance capabilities at that time, and not endorsing or celebrating any extrajudicial killings. Again, this clip was shown on Monday, I believe, February 23, on the first day of the confirmation of charges hearing for former President Rodrigo Duterte. First, ang pag-review ni Duterte sa Davao ay na-misinterpret daw, according to Tesiorna, who said he was there when this clip was taken in Davao City. Again, it was only meant to showcase the new 911 operations center back in 2013 and had nothing at all to do with the extrajudicial killings. It's not clear at this point. We lost the feed, but Attorney Kaufman there sounded like he was talking about that clip when he started questioning the prosecution's submission of documents. And again, this is the part when he laid out the 6 weaknesses of the prosecution's case. The thing that stood out to me the most was number 6, when he said there was repeated absence of any evidence to link hitmen to Duterte. And in any case, he painted a picture of the criminals being inherently unreliable, saying that they're only, giving testimony in exchange for immunity, and that is a compromised testimony. He also said no documentary evidence exists at all of a presidential order. And like I said earlier, unless Attorney Kaufman said, unless there was such a thing as mental telepathy, then there's no way that Duterte could have given the orders for those suspects in the drug war to be killed. All of it breaks down at the level of the co-perpetrators. I'm talking now about the linkages that the prosecutors are trying to draw between Duterte, the so-called perpetrators, and the killings on the ground. And Attorney Kaufman in this session said there's no way. All of that breaks down even when you get to the level of the co-perpetrators. Okay, we'll try to get the live feed back on, but for now, we have to go on a quick break. Of course, this is Duterte's ICC confirmation of charges, a special coverage. Please stay with us. Charges hearing against for former President Rodrigo Duterte. This is day 3. We keep losing the feed, and I apologize for that. I don't think it's at our end because the ICC broadcast seems to be running into a lot of glitches today, but it's not at our end. Nevertheless, I apologize for the issues. As I was saying before we went to break, there is a journalist from Davao who actually has today filed a notarized affidavit of denial. He is disputing the use and representation of the CCTV video shown by the prosecution, I believe on day 1, so February 23, during the confirmation of charges hearing. His name is Ben Ben Jason Tesiorna, and he is disputing this. He says he recorded the video on December 19, 2013. He also says the English subtitles on the video presented by prosecutor Julian Nichols were not part of the original recording, which is a serious allegation. Let me repeat. The English subtitles on the video that was shown at the ICC on Monday, presented by prosecutor Julian Nichols, were not part of the original recording that he took. So now you're looking at his notarized affidavit. Tesiorna is demanding a public apology from the ICC prosecutor for misrepresentation and or recklessness. He also humbly requests the ICC pretrial chamber 1 to order the ICC prosecutor to issue an apology if an apology doesn't forthwith come from the ICC prosecutor himself. Also, he's asking that the court remove the same video from the court registry of records, so strike it out from the official documents. Failure or refusal to issue a public apology, according to Tesiorna's affidavit, will cause him to seek redress against the said ICC prosecutor and others involved, including but not limited to cyber libel, damages, copyright infringement, etc. This was signed just today, February 26, 2026. Tesiorna said that the prosecutor twisted the facts by making it appear that Duterte did not react nor order the police to respond to that particular crime. He also says he has a separate news report of that Agdao incident on December 4, which the police already investigated even before the CCTV was presented to media. He is also contesting the allegation that Duterte did nothing to investigate those deaths of the alleged criminals. Again, this is an incident that was shown, that was a clip that was shown on day 1 of confirmation of charges hearing. Ben Jason Tesiorna, the journalist who allegedly took the video in 2013, said that this was misrepresented and twisted, that it in fact was made was during a media event to introduce and to showcase the new 911 Central Operations Center of Davao City, and that was what Duterte was reacting to. I believe you can hear his voice in the said clip, and he was allegedly using commenting on the video. But again, see, Tesiorna is disputing this. We're not entirely sure why the feed hasn't come back on. It is 10:35 our time, so it's past 3 p.m. Their time, although of course there's a 30-minute delay in the broadcast from the ICC, but they keep going to the placeholder, to the billboard, the opening billboard, to the placeholder billboard rather, saying that there is no broadcast. So we're not sure what is going on at the moment. We're trying to get a reporter at The Hague, Angela Lagunzad Castro, to verify or at least give us some information as to what happened. In any case, before the feed was cut, of course, Attorney Nicholas Kaufman, the defense lead counsel, was making his case and his closing arguments, basically contesting the prosecution's case.
Donc, merci, j'étais en...
Judge Mochok, I was thanking the participants and parties, and then we had a few moments in private session, and now I would like to wish you a pleasant afternoon. We will see you all tomorrow, and once again I thank everyone, and this hearing is now adjourned. We will see one another tomorrow.
And there you have it, the historic legal battle of former President Rodrigo Duterte at the International Criminal Court. That was day 3 of the confirmation of charges hearing. Today was all about the defense. The defense was able to, in 3 parts, to give its submissions on the merits of the case. The case, there were a few themes today. The defense did not argue a lot about the jurisdiction, but it did try to cast doubt on the so-called causal nexus, the link between former President Duterte, then to the so-called co-perpetrators, and then down to the killings on the ground. That's what he had been trying to do. Earlier on, the Attorney Kaufman said there is no smoking gun in this case. There's not one demonstrable incident that shows that there was a direct order from Duterte to kill all the people that are named in the 49 incidents that have been presented here at the pretrial chamber 1. Okay, that does it for us. We will, of course, bring you the latest as the hearing unfolds. Tomorrow is the last day, and tomorrow is also the day of the detention review for former President Duterte, for the judges to decide whether he will continue to be detained. But that does it from me. The ICC confirmation of charges hearing against former President Duterte will return tomorrow, same time. I'm Regina Lay. Thanks for staying with us.
One